May it please your lordships. Dear my lord, the short question arises in this writ petition. The short question which arises in this writ petition. When I am liable to be assessed under the Orissa Value-Added Tax Act, whether I can be assessed under the GST Act. For brevity, sake of brevity, lordship may kindly turn to Annexure 2, page 15. A work was executed by the petitioner.
This is one of the most important litigation in this area
Yes,
nowadays.
definitely, definitely.
Ah,
my
no.
lords. My lords, I executed a work under the roads and roads division. Lordship will kindly see Annexure 2, page 15. Lordship
Yes.
will see a work order date is 21st of December 2018,
Yes.
and it was completed on 9/1/2017. Now the GST came into force with from 1st of July 2017.
Yes.
Now the executive engineer, who has also been made a party here, did not deduct tax, for which I have given a letter. Lordship will kindly see that Annexure 3 at page 19, and I have given a typed copy. The next page your Lordship will turn to typed copy of Annexure 3. With due regard, I am to state that I am a works contractor and I have undertaken various contracts since 7 to 8 years in your division. There have been a few demand orders issued against me by the city and GST authority Sonpur, resulting to less turnover stroke excess turnover pertaining to the financial year 17, 18, 18, 19, 19, 20, etc. And we have prepared appeal for the appellate authority, the JCCT Bolangir, and I am hearing is posted to 25th of April 2023. Here in this connection, I require some particulars of the documents in respect of the above mentioned financial year, like Form 16 quarterly.
Yes.
They passed an order under Section 74 of the GST Act,
Yes.
saying that I have suppressed because I have not shown in the turnover so far as the TDS is concerned. Now, your lordship, I will request your lordship to see Section 54 of the Orissa Value-Added Tax Act, which says that deduction of tax as source from payment to works contractor. May I pray your lordship to kindly have a glance to the Section 54. Notwithstanding anything contained in Section 15 or any other law or contract to the contrary, any person responsible for making payment of any sum to any contractor refer to this section as deducting authority bracket over for carrying out any works contract which involves transfer of property in goods in pursuance of a contract between the contractor and the central government or any state government or any local authority or any authority or corporation. Now, we can omit all these subsections.
Yes.
Shall at the time of credit of such sum, this is a mandatory. Shall at the time of credit of such sum to the account of the contractor or at the time of payment thereof in cash or by issue of a check, deduct subject to the certificate if any produced by the contractor in pursuance of subsection 5, an amount towards tax equal to 4% of such sum in respect of the works contract if the value of the works contract exceeds rupees 50,000. Now, my lords, may kindly see the rule of the Rule 58 of the Orissa Value-Added Tax Rules, which says deposit of the amount of tax deducted from the bills or invoices of the works contractor into the government treasury. The amount of tax deducted from the bills or invoices of the works contractor shall be deposited by the person herein before referred to as the deducting authority into the government treasury within 1 week from the date of deduction by a challan in Form VAT 317. That Form VAT 317 has also been given 605. Form VAT 605. Yes. Certificate for deduction. They will, after deduction, depositing the tax, they will give me a certificate. Now, executive, the contractee did not deduct the tax and did not issue me the certificate for which I am made to suffer. And I have made mallards.
This is the first time.
First time mallards. Lordship will see for the, beg your pardon?
You have given copy?
Yes, yes. Notice has to go mallards to the executive engineer, roads division, Sonpur.
What do you
Your
say?
Lordship, may kindly show press the argument of my Lord Senior with great respect. Your Lordship may kindly turn to that annexure to what my Lord Senior has shown to you.
Which annexure?
Annexure 2, page 15. Your Lordship, the operative portion, Your Lordship may kindly turn to page 18.
18.
Your Lordship. Here the total value is 2,64,731. Your Lordship got it? Now, Your Lordship may kindly turn to page 23, the assessment order under section 74, Your Lordship. Your Lordship, that is annexure 4, start at page 20, and the operative portion is at page 23. The assessed value, which has not been disclosed by the petitioner, is at 1,88,03,03,082. So, admittedly, it has been admitted at paragraph 6. So, admittedly, there is other receipt which has not been disclosed, Your Lordship. For non-disclosure of receipt in the return under section 3B, under return 3B, Your Lordship, this assessment has been completed under section 74. This assessment order is appealable, and accordingly, the petitioners filed appeal before the first appellate authority, and Your Lordship, the impugned order is at page 9, annexure 1, which is impugned here. This annexure 9, annexure 1 has been confirmed, Your Lordship, the DRC 07, the assessment order has been confirmed in first appeal. Admittedly, this first appeal, annexure 1, is to be appealable before the tribunal. Since, Your Lordship, the tribunal is not functioning, Your Lordship, due to declaration as ultra virus by Hon'Ble Madras High Court in case of Union of India versus, Revenue Bar Association versus Union of India. Your Lordship, since it has been declared as ultra virus, section 112, the appointment portion has been declared ultra virus. For that reason, Your Lordship, now this is before Honorable Supreme Court, and in this Finance Act 2023, it has been already inserted. Now, Your Lordship, under similar circumstances, since Your Lordship, tribunal is not functioning, Your Lordship, there are no,
That is fine.
since there is no alternative remedy, Your Lordship, so the read court
nobody questioning that.
admitted. Now, Your Lordship, so far as the admission is
may I
concerned,
reply,
Your
my
Lordship,
Just
May-
one.
May I reply?
so Your Lordship, after admission, Your Lordship, this Honorable Court passed the interim order, Your Lordship, that since as per the first appeal order under section 107, Your Lordship, they have to deposit 10% of pre-deposit, Your Lordship, at the time of filing of first appeal. And the first, and under section 112, subsection 6, so far as the pre-deposit before the tribunal, that is 12% of the remaining tax. So this Honorable Court in identical matter, Your Lordship, admitted the writ petition and directed at interim order that since it has been deposited 10%, the petitioner has already deposited. So the balance 20% of the remaining tax is to be deposited, and the balance tax interest penalty is to be stayed. So this is the case, Your Lordship.
Ballots, in reply, I will submit. So far as the annexure to which the standing council has shown.
Standing
that-
council, please sit. That's better way.
Your Lordship.
Yes.
You should not
This
sitting
is
down.
one of the sample copies. If I would have enclosed the entire work order, all the work orders, it would have been more than 500 pages. So this is only a sample copy, mallards. This is not the entire amount which I have received. And admittedly, all these works have been completed before the commencement of the GST Act. And because the executive engineer and your lordship have seen the letter of the executive, the city GST demanding the TDS.
One thing, since your interim order has already been passed, and in 20% the remaining amount you are going to deposit within 4
My
months. So that amount has not yet been deposited, right?
20% I have to deposit in the tribunal if I prefer an appeal. Now, my lord, so
But
far
here-
as that
here
order
the
is,
tribunal is not there.
tribunal is not there.
Yes.
So this honorable court has said that you deposit 20%. May I submit, my lord, subject to your lordship's convenience and subject to what your lordships pleases, that since this is an ex parte
Hmm.
order,
Yeah.
let the matter go back to the first appellate authority. Let him decide.
Why? Why should you go, sir?
Or the lordship may,
Will he hear it? Yeah.
yes,
Will decide.
lordship may, yes, issue notice.
I mean, I don't think, it will go back there, then they will.
No, it's all right. It's all right. That is why I said that you're subject to your lordship's pleases.
You deposit this amount and let them in the meantime file the reply.
Yes.
Your Lord-
10%, my lord, because 20%
No, your lordship.
has all the
10% is it is within.
First appeal.
first appeal.
first
Yes, sir.
Then, my lords, 20% of the entire amount, my lords. This is only a discretion of this honorable court, my lords.
Yeah, the order has been passed, you have to.
But that's right, my lords. I'll not, so I'll not bargain.
That will hear it out.
I'll not bargain, my lords.
Since there is no tribunal,
Good.
there's no harm in hearing here.
Your lordship.
So why should we again go
Lordship,
back,
yes.
come
Your
back,
lordship.
Yes.
back for the.
Many matters, your more than 500 matters have been
And I
admitted.
think on similar kind of cases have been decided recently. One judgment from Telangana High Court, I think, has come. I'll just find out. what
Yeah,
happened.
Lord.
There's some issue, and a similar issue.
Your lordship, that
Thinking
is
what
the
is actually
difference. That is
decided.
the difference in between 2A and 3B. But in 3B, the petitioner have to
File
file.
and reply.
Your lordship, file.
Lordship may fix a date.
Yeah. In the meantime, you deposit them.
I'll
Learn constable.
Your lordship.
And the revenue. File the reply. Within 2 weeks,
4 weeks, your lordship.
within 4 weeks.
Your lordship. Your lordship can tag this matter because there are many
There are
matters.
other matters.
Your lordship,
Give
in the paragraph 4,
give this,
in that order,
Oh, it's
paragraph 4, your lordship.
4 weeks. And the regender thereafter?
within 2 weeks.
Within 2 weeks thereafter.
Yes.
Within regender. This the matter along with, what is the list?
Your lordship, there is
5501.
release this matter along with WPC number 5501
There's only
2023.
one matter. You're saying.
No,
so
many matters, but this is the lead matter, your
Okay.
lordship.
This matter on. Did it come on 30th October?
30th October. Much obliged.
In the meantime, you deposit them.
Balance. That
And the
interim order
interim order
subject,
continue, subject.
Subject to.
subject to deposit balance,
Deposit.
balance amount will remain state.
Your lordship, 20% of the remaining amount.
I'll deposit within 4 weeks.
You deposit within that.
Yes.
Careful, your lordship.
Next.
Item 2. 2 is similar.
Same.
Similar.
Sam. Sam. Next.
Item 3.
3.
Question has been framed. At page 5,
Yes.
6-1.
Yes,
Whether the
that's
facts and circumstances of the case, the learned ITA is justified in deleting the addition of 10 crores made by the AO under section 115 BC of the IT Act when the prescribed particular and details were not furnished by the CC. Second, whether in the fact and circumstances of the case, the learned IT is justified in allowing the administrative expenses disallowed by the AO when supporting evidence were not produced by the CC. Whether in the facts and circumstances of the case, the learned IT is justified in law to allow the carry forward of loss when the expenses claimed by the trust were found not to have been applied for charitable purposes. And last question, whether in the facts and circumstances of the case, the order of the learned IT
just a minute.
is not page 5 and 6.
You have filed the reply at the other side.
No, notice has not been issued.
Substance.
Not an issue.
Case is not been admitted.
No, what is the order about this?
Substance.
Yeah,
No issue.
the review petition is filed.
Order is not.
First, it was dismissed.
What is the first order then? The order pertaining to this
That was review petition in file.
26/11/2018.
Yes, yes. That is it is below taxable limit,
Okay.
monetary limit,
Okay.
is not applicable to this case. Hence I filed a review petition and that is admitted and allowed.
Okay, this is after this.
Yes.
Uh, Who is for the other party? Notice has not been issued.
Notice and notice.
Okay, issue notice. To the opposite party. Via registered post?
Yes.
Returnable on
Within a week.
15 September. The party is from which place? Bhubaneswar.
Yeah.
So 15 September. Because it may be filed within 3 working days from today.
Item 4.
Your Lordship, we have filed memo of appearance.
Yes, please give it.
We have given in item number 3.
4 months, 2 weeks time, then you can counter. Counter is ready, but.
Let him first appear the other party. See?
Yes, sir, I'm
You have
for
fair?
that.
Alright, okay. So, you are, what is your name?
My name is J.R. Behra, Jyotiranjan Behra.
Jyotiranjan Mehra.
I am coming, ma'am.
We have some notice. We have some notice on behalf of respondent. Give a copy.
Yes.
So, let's fix it for hearing
Yes, ma'am.
on with that.
The month
Then
of-
you file a reply. Will you file a reply within 2 weeks?
Yes, ma'am. If you file, then I will file, my lord.
Uh-huh.
If you file the counter, my lord, signature-
I have not filed counter.
Sir, he is a petitioner.
no, my lord,
I am
I'm for the
petitioner.
petition.
You are
I'm
for
for
the
the petition. Yeah, ma'am.
Oh, you're appearing for the revenue, I thought.
I am from the revenue.
But, okay. So you filed a response?
Yes.
So let the pleading be completed within 3 weeks,
Okay.
both sides.
Yes, sir.
Counter agenda. Let the pleading be over within 3 weeks. This is the matter on 18th October. 18th October.
18th October is holiday, my lord.
Huh?
18th. No, okay.
I'm not watching this.
Yes, yes, my lord.
So you exchange your counter agenda,
Yes, sir.
whatever. So I'm not writing counter, here. Pleading be complete.
There is a entry, my lord.
Let it be fixed for final hearing. Final hearing.
There is a-
They want to
Internet.
continue. Final hearing. This is for
Yes,
final hearing. If pleading is complete, it will go for straightly final hearing. No
Yes, sir.
further adjournment is this.
Item 5.
5.
May it please your lordships. Here is a case, my lords. Even though the Commissioner of Income Tax is empowered to condone the delay up to 3 years, he did not condone the delay in filing my audit report, that is form number 10B.
Yes.
Because I am a charitable society and I have to file the
What is
audit
the
report.
total days of delay?
Yes, 38 days, my lords. Oh, total 38 days. If your lordship will kindly straight turn to the circular, annexer 7, page 35, my lords.
7.
There- Yes, page 35.
Yes. Condemns from delay. under-
Yes. There the annexer
365 days.
Yes. So beyond 365, up to 3 years.
Yes,
max.
3 years.
Now, my lord, admittedly, there is a delay of only 38 days because my accounts could not be completed.
Okay.
My lords,
So that is the only issue here. I mean,
that is the only issue. And they have filed the counter and they admitted in the counter affidavit. I say,
they filed the counter?
yes, yes. And your lordship will kindly see. I am reading from the counter affidavit itself. I'll just,
Just a minute.
yes.
Counter 9. It's not in our record. Counter.
Let it come then, my lords, tomorrow.
Uh,
No, I'm giving it.
Oh, okay.
you don't have counter.
Small counter.
My brother is also not done with counter.
Dida diontu. अरे
Read it.
आवडे दियो
ताको दिया copy.
Filing, e-filing, that is why they not ready. Revenue is to file.
Sir,
also
then
e-file.
it is condemnable. Why you are not condemning?
Yes.
So that he should have condemned the
That
delay.
is why it came to.
And they have
on
said-
record.
in para 3.10 comments, your lordship, as per the direction of the board, right, circular number 16 of 2022 SSC application for condemnation delay under section 192B of the act was admitted. The condemnation application was rejected by the Commissioner of Income Tax exemption as SSC failed to submit any reasonable cause.
Hmm.
That is the,
He has to file only a condemnation petition.
I have
Along
filed,
the petition.
I have filed that, my,
You have not filed that.
yes, I filed. Yes.
Where is the petition?
Yes, I'm. Annexer 4, page 28, you should find.
Annex of 4.
Yes, page 28.
But this later you have filed later, not on the same date.
It was
I have
delay
Not
of
part of
38
the rec.
Yes, yes, it was delay of 38 days.
38 days. Madam.
No, this application
to
was
file for
filed
condemnation
later.
delay.
This,
When I
when did you
filed
file this application?
When I filed that application, my lord, I was asked to submit about the explanation regarding delay. Then I submitted.
But that should have been part of your this application, original application.
My lords,
Sorry, the additional before.
upload, yes. My lord, page 29, lords will kindly see. The
29.
SSC has filed form 10B, that is the audit report under section 12AB for the charitable trust for the above mentioned year on 24/3/21 by acknowledgement number 1. So the due date for the same was 15/2/2021. Due to some unavoidable circumstances, the accounts could not be finalized because, my lords, the accounts are the main thing.
Yeah.
For claiming exemption.
Okay. Delay control. I'll pass it later on.
Well, much obliged.
Item number 6.
Next. Next.
Item number 6.
6.
Your lordship, I am for the opposite.
Who is for the petitioner? None?
Your lordship.
2016 matters.
Your lordship, in fact, here petitioner challenged annexure 1, that is the assessment order.
Yes.
In fact, that is not the assessment order. Your lordship, the petitioner challenges,
Let him come. Let him.
Your lordship.
Just we should
Your
give him
lordship.
the opportunity.
your lordship,
Non-appeals for the petitioner.
it is only appeal effect order.
Non-appeals for the petitioner. Though the case is, the petition is pertaining to the year 2016. This court offers an opportunity for the petitioner to represent through its counsel or through the officer of the company. Now, next date of listing, that is this the matter on 9th October. 9th October.
Item 7.
7, my lord, on behalf of Mr. Sanjeev Panda, I am appearing for the petitioner. Here again, the as a first appeal order under the GST Act is under challenge. As because the tribunal is not there, and I have paid 10% at the time of filing of the first appeal. Now I have approached this honorable court. The similar order will be passed as item number 1.
Copy has not been
I am
submitted.
giving the
Give a
copy.
copy.
Yes.
Give a copy. You see the last order, but no, you are saying some order.
I'm also. Same.
Item one.
You have paid that amount?
Yes, I have paid the 10%, now I have to pay 20% of the balance.
Ten order. That is something. Okay, this is the matter. You file your reply?
Your lordship.
Uh.
It can be tagged with that
Item one.
item 1, 2.
Next,
Item number 8.
8.
Lordship, last occasion I had short copy and then reply to.
No, not reply. Your lordship, see the last order.
Copy has not been served.
Copy has not done something that day.
Yeah, now you have got it.
Yes, now I got it. He has to place the case, not yet admitted.
That did not copy not so.
No, that day you have solved the copy, but court has not admitted only because you are the urgency, the court has passed this order.
Not, okay, what is the case about?
Lordship, in fact, Lordship, they should file a reply in this case. The Lordship can only.
They will file the reply, just you. Just argue.
Lordship kindly say annexure 1.
Now, what is the case about?
Lordship, on the self-serve grant, one authority grants me benefits under the statutory provisions.
No, what is the case about?
Lordship kindly say annexure 1, Lordship.
I'm asking what is the case about? What is the case in brief?
This is imposition of service tax
Hmm.
without giving me exemption, Lordship, which has been granted on the schedule 67(2) of the Act, Lordship.
Hmm.
By making assessment of 2 consecutive years, Lordship, in 1 year, one authority is granting me benefit, and the second authority, Lordship, is not granting authority. Lordship kindly see, order Lordship kindly see annexure 2, the first order at page 33.
Annexure 2, yes.
Annexure 2, Lordship. Just Lordship, Lordship kindly come to page 57. Just I'm showing the operative part. 57, first para, last 2 lines. In view of the apex court's ruling, I don't find any merit in the contention advanced by the assessee claiming exemption without support.
57.
57, Lordship. Then, Lordship,
Just a minute, just a minute.
Lordship, sorry.
You have read everything. I have not yet got the
Sorry,
reason.
sorry, Lordship.
You are master of the facts of your case. We have to shuffle through so many things.
Sorry, Lordship. Because I had impression my Lord friend will file a counter. That's why, Lordship, I have.
No, just I want to know what is the
I'm also not prepared.
gist of the case about.
Lordship.
That he'll do.
Lordship.
Just we have to have an idea of the case.
Sorry, Lord.
Yes.
Lordship, kindly 57, relying upon judgment, he is saying that the benefits not, last 3 lines, Lordship.
Sir, this
First
is
paragraph.
one thing, please, for God's sake. Here, one thing I always tell in my single bench also, I used to do that.
Lordship.
Please tell me the brief of the case, then go to the this annexure 1, 2, whatever.
In
What
fact,
is the case about? You have not yet.
Lordship,
explained me.
the petition.
What is the case? What is the
Lordship, the-
petitioner doing? What is he doing? What for? What? Is it sub notice? You don't know anything.
The petition, the was contractor, Lordship. He
You
has
have to say
executed a
that.
government contract
Okay.
and service tax is not liable though so far the government contract is concerned.
What contract on what
Was-
transaction? What transaction?
Yes,
is
Lordship.
not liable?
So
You have to
there
tell
is the exemption, Lordship, under section 67(2) of the Finance Act, Lordship.
that. Okay.
And Lordship, kindly see, I have annexed the notification that is page 63, annexure 3. This is a government circular of 2012. The notification, Lordship, page 63, annexure 3, Lordship. In view of such notification, I am.
Now what is notification about? Let's see the notification first.
Lordship, notification, Lordship, kindly page 63,
I
annexure.
am there only, just read
63, Lordship.
which one you have.
No. Lordship, in exercise of powers conferred by sub-rule 1 of section 93 of the Finance Act 1994,
Yes.
herein after referred and the supersession of the notification number 12/2012 service tax dated 7 March 12, published in the Gazette India Extraordinary Part 2, Section 3, Sub-Rule 1 of the number GSR 210E dated 7/2012, the central government being satisfied that it is necessary in the public interest, so to do hereby exempt the following taxable service from the whole of the service tax leviable there under section 66B of the said act, namely.
Okay.
Then a lordship can state that come to page 56. Page 66.
Yes, which
Page
paragraph?
66, page 66, 12A, lordship.
12A.
12A. Services provided to the government, a local authority or a government authority by way of construction,
Erection.
erection of commissioning, installation, completion, fitting out, repair, maintenance, renovation or alteration of.
Hmm.
Then lordship a civil structure or any other original works meant predominantly for use of other than for the comments of industry or any other business or profession. Then let's say come to 13. Services provided by of construction, erection, commissioning, installation, completion, fitting out, repair, maintenance,
So
renovation.
you are seeking exemption. under
Lordship,
this
I'm
which
seeking
provision?
exemption.
Okay.
And the Lordship kindly see the 29 also gives
Okay,
us-
you file a reply.
No, no,
Lordship.
here your lordship, what he has challenged, he has challenged the adjudication order.
Hmm.
And in the adjudication, what he has submitted now has been considered in page 57.
57.
Yes, that he says, Lord, that if he's not, he's failed to produce the detailing of all these things, whether the exemption is available to him or not. Therefore, it is clear case of appeal because fact is there. There is not a case that without jurisdiction, there is no error record, there is no natural justice. Therefore, it is to appealable order. Even assuming whatever he is stating is correct. And if it has been discussed in the order and after detailing the order has been passed, it is appealable order. So how can we challenge in the read code? That is first not my submission. And all these things is relied upon by the Supreme Court judgment, the adjudication authorities passed the order. But lordship, see whatever my friend is submitting, it starts from page 4.7, page 56.
56.
Yes, and that continuing in page 57, I'm starting 1, 2, 3, 4.
Since jobs done by the SSC falls under the classification works.
Yes. No, I did.
construction.
I 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. Paste below 11 line of the page 57. I noticed that Government of Orissa issued an office memorandum so duly signed by the Principal Secretary within public domain where the operative clause para 5 that exemption from service tax for ongoing construction maintenance of work government would be applicable only if such contract enter into prior to 1st March 2015. In this regard, I take support from the decision of the Honorable Supreme Court in Meridian Industries versus so when it is held, unless the notice make out a clear case in his favor, he is not entitled to claim of exemption. Unless the notice make a clear, he is not entitled to claim exemption by the notice for the availing
Meridian
benefit.
Industries case.
Yes. Therefore, for the availing benefit under the exemption notification, the condition have to strictly comply with. Exemption notice has to comply with strict compliance. It's not that somebody is mentioning that and claim exemption. Strict proof of the same is required. Therefore, once it is an adjudication or passed, they should file an appeal. There is appeal provision. So you could have filed and if factually is different, he is eligible, he is doing the work under the government and these portions of work coming under the specifically under the notification punishment and so on. So therefore, it is not maintainable even.
So this is passed by.
This is passed by the principal commission. He has to file appeal before the SSTAT.
May I answer, Lordship? In 2 lines, I can make a all submission because knowing fully well, we know the appellate provision, Lordship. We have taken that averment. But my learned friend outside I was making a mention, they should obtain instruction. Lordship, can you see the peculiarity of the case? Lordship, kindly come to Annexure 2 for a moment, Lordship. Lordship, Annexure 2, it is passed on 18/4/2023, Lordship. It is, Lordship, kindly see, this order is by the Lordship, Principal Commissioner, G.SATAPATHY Central Excise. And Lordship, kindly see,
So you have a appealable.
no, Lordship,
No.
why I will go to appeal, Lordship?
Why?
But Lordship, kindly see. In Lordship, kindly, what is the assessment here? The assessment here, Lordship, it is 2015-16 and 2016-17. And
At
Lordship,
that time that this thing.
no,
was also not there.
no, I'm not on that.
That was SSTAT was.
I have taken that averment, Lordship.
Go to the SSTAT.
No, why I'm not, why I have approached Lordship, that is the reason. That's why Lordship, I was saying.
What is the reason? sir?
Yes, Lordship, I'm coming to Lordship. Lordship, kindly, this is the year of financial 2015-16,
Sir,
16-17.
what is, how does it make?
Lordship, let me
Because
complete.
of the year.
No,
should it not go to the appeal?
let me complete, Lordship, because there is a pupillate, Lordship. You will admit my application, Lordship. Lordship, kindly see, is it the year 2015 and 16, 17? And Lordship, kindly the pupillate were in both the assessment, the work is same, 3 works,
No, no,
Lordship.
I am not on merit.
No, no.
Merit, you have a case, maybe.
No,
But since there is appealable order.
No,
it is okay.
Lordship, kindly come to Annexure 4. The same authority,
Hmm.
Lordship, same authority here gives, no, I will not give an exemption.
That is nobody is denying, sir.
No, Lordship,
See,
then
when you have
then Lordship, kindly come
provision of
to-
appeal, approach the appellate authority.
I will take a financial burden, Lordship. If you,
Why financial?
No,
burden? Going to the appeal is not a financial.
No,
burden.
if I will deposit some amount there, Lordship. Because why, if I have executed government work, Lordship, kindly come to page 102. Came to same authority, Lordship. Lordship, it is.
Sir, these are all, you are arguing merit.
No, not merit.
All the jurisdiction.
Not
Go there,
not
what is the
merit,
appeal
Lordship.
for?
On the
Foreign
face
media,
of the document.
They explore that forum.
No,
they
no.
will try to come here.
On the face of the documents, Lordship, the authority cannot take a different view. The same authority can take a separate view.
Maybe that can be agitated there.
Lordship, it can be reviewed. If your authority, Lordship, can see the same
Even-
authority,
even-
the
even
fast order,
authority
Lordship,
there.
can see the fast authority.
Had there been no authority, now GST is not there, so people are approaching directly to the High Court, there's no issue.
No,
But when that your cessed is there, you
No,
should have approached.
had it been there is no financial burden, I must have been there, Lordship.
No.
Lordship,
Financial
Lordship,
then everybody will come to directly to the financial
Because,
burden, they'll come to,
Lordship, I'm
High Court.
executing government works, the contract, Lordship. There is
Sir,
no
one
service
thing,
tax,
one thing.
file deposit, Lordship.
See this.
No, Lordship,
See both sides. See, revenue also should not be left high and dry. They should also get some percentage. That's why there is a, to secure that percentage of you have to deposit there. That's there.
But
If you say financial burden, that's why I'm
No,
going to High Court. This is not the case.
if I have not taken a single pie,
No.
if I have not, Lordship, can you come to page 100,
So
Lordship?
then your money will be. If suppose you win the case, get back your money.
Lordship, can see my difficult, Lordship. Lordship, this is
When there is a statutory remedy available to you
statutory remedy.
and or in the form of appeal,
Lordship, it can.
why you would bypass such a forum?
Lordship, state have come to high bypass, Lordship, come to page 102. Lordship,
No,
page
no,
102.
there these 100 to 100 is not explaining that bypass. Sir.
Lordship,
This is not explaining.
It is report to decide, Lordship.
Just because you
Lordship,
have to deposit some
Carlos-
amount, it cannot bypass.
Lordship, the carelessness, careless attitude of authority should
No,
not
that
make-
may be.
Lordship, kindly come to
That
102.
will be decided by the.
That is not a ground to.
Lordship, kindly come to 102.
No,
Please come to 102.
No,
Lordship.
no.
Please come to 102,
Sorry.
Lordship. Lordship,
We
please.
are-
Lordship,
you approach the
Lordship,
appropriate-
definitely, Lordship, because Lordship, it is a now and Lordship, even implemented Lordship, sending to appellate authority.
Sir,
That's true.
appellate authority is
No,
there,
but
but there, what
Lordship,
can we do?
when the scope
So
is
the
there, to
act
interfere,
provides for an appellate
that's
authority, you have
true.
to approach
That's
that.
true, Lordship.
What is it? No.
Even if Lordship, even if the statute provides Lordship, Article 226 is never.
Sir, then to the, all, remove all those appellate
No, I'm not
authorities.
saying Lordship.
226 is there,
I'm
you'll enjoy.
saying
Please come.
exceptional.
Everybody is now bypassing the National Consumer Forum, they're approaching here. This is not done. What is the sanctity of the statutory provision then?
But
The
Lordship,
parliament has passed a particular legislation and the entire, the what, 800 some odd members have, they have passed the legislation and now,
Lordship,
how can you just bypass?
Lordship, at the same time, your Lordship shall settle the law.
No, I'm
If
not.
their point of law involves Lordship, definitely Lordship interfering. Lordship,
No.
please come to 102 Lordship. For a moment, Lordship. Page 102 Lordship. 102 Lordship can come.
You have, give me some case law. Let's-
Yes, case law. I will give case law.
Give me case law.
Lordship, then.
Because there is a financial
Yes.
burden involved.
No,
also
not
I
financial burden.
approach the
No.
226.
Because there is a point of law involved, your Lordship can
Sir,
interfere. That is, I
point of law, there can also, it can be done there also. Who can stop? That is also an appellate authority. There also.
then
that
let me
point
come
of-
Monday Lordship, I will produce two judgments. Lordship.
No, show me today.
No,
Why one day?
today I'm not, because in
Is it
fact,
not done?
my impression, Lordship.
No, impression.
No,
really.
Lordship, kindly consider two assets.
See, I'm a conservative man.
No, that's true.
Ah.
That's true.
So I'm always, I follow the conservative mode, not this modern mode. Okay, so
Lord-
please
Lordship.
ensure that.
No, I'm not on that, Lordship. Lordship, kindly see my submission before Lordship, because today is in fact I'm not feeling well.
No,
So I'm not.
fine, that maybe you can take time for not feeling well, that's
Yes,
different.
no,
thing.
that's why I'm
You cannot
saying.
bypass the
No.
authority.
That's why Lordship is saying they will file affidavit. Let me come Monday, Lordship.
Okay, show me, let him.
Monday,
spread
Monday,
his case.
Monday, Lordship.
Okay,
Lordship.
Monday, Monday के तरीके से.
Out to next do that.
Or 12 कर दे,
12.
12 कर दे.
Lordship.
Give me your case.
Yeah, Lordship.
2, 3
Three, Lordship.
and preferably
not-
Supreme Court. is
So
better.
only
Supreme Court also decide financial or not.
I know that. Let him To satisfy his.
No, no issue, no issue.
Lord,
Okay, nice.
I'll try to
No, 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 not a problem. We are trying to just.
Let's increment to continue. Right for
Next,
Item 9.
9.
This matter has instructions to appear, my lords, for the appellant, my lords.
Yes.
There are three appeals.
I think this pleading is complete. This matter?
No, my lords, the questions of law has not yet been admitted, my lords.
Sorry?
The questions of law has not yet been admitted, my lords.
Oh.
So if your lordships
This
will
is
permit
a
me.
2019 matter. no?
My 19 matter, my lords, unfortunately, it could not be listed for some reason or the other. So briefly, may I just state
This is
the
the first time coming. this
no,
matter.
my lord, so far as 11 is concerned, it's coming for the first time.
But this is what-
Initially,
But order is here the appellant list on 5th July 2023.
no, but what had happened, my lord, OTA PL 10 of 2019
Ah.
was listed before their lordships in court number 1. And a mention was made.
But here, this is OTRPL 1.
11. 11.
This
So
same-
a mention was made before your lordship, before the earlier bench, my lords, that this matter of 10 of 2019 may come up along with 11. So today 11 has come up without 10.
That's
my
why
lords.
it has come.
My lord, I'd humbly pray, my lord. In fact, there's another appeal because there are 3 periods
Let
involved.
the 3 appeal be heard together.
My lords. So
What
your
is-
lordship,
give the number.
number is one is 10 of 2019, OTA PL 10 of 2019.
Multiple 10 of-
Present one is 11 of 2019. The other one is 12 of 2019. my lords.
Okay.
But I would only humbly pray, my lord, your lordships have to admit the questions of law. Then
Yes, yes.
So
Who
may-
is the opposite party?
I'm appearing for the revenue. Also appearing through VC, my lords, for lordships, from audible and visible, my lords.
Yes, yes.
My lords, the OTPL 10 of 2019 had come up last week.
Sorry?
OTPL 10 of 2019 had come up last week, my lords. So this is gone to 21st September. So same, my lord, same impugned order, different periods.
Oh.
it's a common.
So,
Common
so
order
this principle has to be decided, but it can be heard together.
can be heard together, my lords. It can all
Yeah,
be taken.
so
up.
let's fix a date and we can hear it out.
So I was
Yes, my lords.
Now
OTPL
get ready for final hearing.
My
No
lords, that was the order.
further,
My
you
lords,
hear
last
it and
occasion, they had
finish.
sought, my lords, they had sought time on the last occasion.
Yeah, also come prepared with a note
Note
of
of submission, my lords. Well, that is all ready, my lords. On 21st
okay.
September, lordships, that is fixed the other one, OTPL 10 of 2019.
So
So may I just
which
humbly
date will
pray-
be suitable to this?
My lord, may I just humbly pray it was sometimes in the second week of October, my lord, subject to your lordship.
Second week of October, Mr. Mahapatra?
My lords, I have no problem.
Okay, second
So-
week of October. So
My
let
lord,
it
then
be
just-
heard on 12 October?
My lords.
12 October, 12
In the me-
October. Now this reading is complete.
No, my lord,
No, my lord,
speaking
this is
not-
for admission. This is yet to
It
be
is only
admitted.
for
my lords.
admission.
It has not been admitted as yet, my lords.
Okay.
So the questions of law, my
Question
lord,
of law. Okay.
my lords.
Sorry, I thought
Not
it was.
been-
No, my lord, just come. That's why your lordships were
No, no,
pointing out it's a
because
2000
I think the 2019. I
right. So
thought
the age of the matter, my lord.
age of the matter.
Well, may I just briefly place the facts, my lord.
Yes, please.
Lords, this, so far as Paradip Port Trust is concerned, your lordship knows, my lord, they have a prohibited area, which is known as the port area, my lords. So no one can come within the port area without the permission of the Paradip Port Trust, my lords.
Correct.
Now, Southeastern Railway, now East Coast Railways, my lord, they had railway lines, my lord, connecting up to the port area, my lords. But so far as the port area is concerned, my lords, that part of the Southeastern Railways, now East Coast Railways, is maintained by the Paradip Port Trust, my lords.
Naturally.
And the goods from the wharfage or from the warehouse, my lords, are loaded.
So railway pays some.
Railway pays us. Well, no, we collect that freight charges and we give it on a daily basis to the railways. In return for maintenance of the tracks and other allied one, we receive some amount of payments from the railways, which is known as terminal charges. my lords. So the question, my lord, is that we are registered under the service tax authorities as a port service, rendering port services, my lords. Question, my lord, is that under the impression that these terminal charges are nothing but only received for the maintenance of the track which belongs to the railways and the wagons, whatever is belongs to the railways. So these are not amenable to the service charges. And we did not pay service charges. Then audit was has taken place. And for the periods, my lords, if your lordship would kindly turn to page, the impugned order, page 73 of the impugned order, my lords.
73.
73, my lord. That's the CESTAT order, my lords.
Yes.
There's a table in the first. Your lordship got it?
Yes, yes.
Your lordship would see that there's a table of period 16/7/2001 to 31/3/2006. The second period, which is before your lordships today, is 1/4/2006 to 31/3/2007. And the third period is 1/4/2007 to 2008, my lords. So for these three periods, they said that this is nothing but, my lords, business auxiliary service, my lords.
Okay.
So the dispute in this particular case, my lord, is our case is it is a does
So
not
the
come
question is whether the terminal charges that is levied.
leviable will come within the business auxiliary service or not. Because our stand was that we were already registered under the port as a port service, my lord, under the service tax authorities. So since this does not fit into the definition of port services, we did not pay service tax. Of course, subsequently, after much tussle, my lords, we kept on collecting terminal charges from the customers, and we handed it over to the railways. So in fact, after this period, there's no dispute. So only for these three periods, the dispute is there, my lords. So far as the questions,
Just let him complete.
Mr. Mahapatra, just a minute, my lords.
Sorry.
So far as the questions of law is concerned, my lord, it's at page 70 of the brief, my lords. It's slightly long, but I'd leave it to your lordships.
I'll tailor it.
My lords, my lords.
70. Yes.
Page 70, your lordship.
Yes.
Whether,
So many questions.
my lords,
I think that could have been made shorter.
it could have been made short, and the lordships have the authority not to cut short, my lords. May I just frame, my lord, this question number 1 would be relevant.
Yes.
Whether it is just, proper and legal on the part of the learned stat below to confirm the order passed by the commissioner holding that the activity undertaken by the appellant for railways will be appropriately classified under the business auxiliary service and liable for payment of service tax. So this will be a relevant question.
This is the important question.
The other question, my lord, is relatable to the penalty. Here, whether it's just and proper on the part of the learned stat below to confirm the order passed by the commissioner so-and-so, service tax, so-and-so. It's a consequential order. Question number 4, my lord, and 5. 4, 5, and 8, my lord. I think may be considered by lordships to 1.
4 is okay. 4 is fine.
My lord, 1, 4, 5.
Legal part of the
8 1 also.
1, 4, 5, and 8, my lords.
Yes.
8 is whether in the present facts and circumstances, terminal charges collected with the appellant from railways would be liable to service tax under port services. So I think these 4 questions would.
My lords, may I submit, my lords? May I make a submission before lordships admit the
He's just arguing, sir. Just wait.
I'll give you the chance. The other matter, OTPL.
Just a minute. This is not the way. When the senior counsel is arguing, just wait. He is showing some question of law. Yeah, what do you want to say?
Last order, OTPL.
These are not question of law.
No, my lords. I mean, OTPL 10 of 19, lordships had indicated. Lordships, when the composition of the bench was different, lordships Justice Sinha had indicated that at time of admission, at the time of the hearing will be taken up of the entire matter, and all the appeals will be taken up together and heard. So I may be allowed to address because there are concurrent judgments of different tribunals.
No, who is stopping, sir? So it is if it is allowed, then it can be heard in detail.
Sir, we are in the first step.
In the first step only.
The first step, my lord.
So why in the first step you are so hurry?
At least that the questions of law be admitted. Then
if you want to argue, both of you argue. I am ready to even finish today also. I don't have any problem.
My lords,
I believe in finishing things, not unnecessarily procrastinating for this day, that day.
But your lordships always prefer.
So what do you say?
My
You
lords,
want to argue fully?
I'm ready, my lords. There is a compilation I wanted to hand over. That I would hand over so that the
compilation I have to read also, no?
So
I'll file, my lords.
Compilation can't be.
My lords, I am only requesting that I'll maybe permitted to place all the relevant notifications, the compilations.
Sir, this is really a substantial question about what I felt. I've read the file. So this is a substantial question of law. Let it be answered. Let you file your reply. Then we can answer it in proper perspective.
I think my learned friend is not a newcomer.
No, he's not. I know
he's a seasoned counsel in the Supreme Court.
He has been doing it for a long time.
And he's a seasoned counsel now in the Supreme Court, lords.
So
the preliminary stage of a OTPL is for admission of the case.
First let it be admitted. Sir.
Why my only endeavor was because the last order was it will be taken up for admission here.
Sir, the order, last order, that is a different way. I have my own way of doing things. My way is admit it, hire it, and finish it. Don't unnecessarily procrastinate further. So I am admitting it, okay?
My lords.
That was the question of law. Was this first one? No,
1, 4,
page 17. Question number 1,
4,
4,
5, and 8.
5, and 8. The following questions of law have been framed. The issue notice to opposite parties.
Notice, my lords, may be waived. I'm entering up here.
Notice, it is Mr. Prasenjit Mahabhadra, waives of notice. On behalf of issue notice and waives of notice on behalf of the opposite party. So, which day will be, and in the meantime, you file a reply?
I'll file, my lords.
Okay, I'll consider the petition. Respondent is granted. 4 weeks time to file your reply?
My lords.
No, 3 weeks, 3 weeks. Let it be 3 weeks.
I'll
3
file.
weeks and 2 weeks further for rejoinder. No,
I mean,
counter.
this is an appeal. He may not require to file a rejoinder.
Yeah, please. He'll give you coffee, sir.
May I submit?
Ah.
May I submit? In OTAPL, these are appeals, my lord.
Yeah.
Only question of law has to be decided.
Yeah, that's correct.
In this case, there is no reply is needed. It is up to your lordship to decide the question. Only written submission can be sufficient.
Written submission.
My
Sorry, sir, written
No, no
submission.
reply is needed.
This is appeal.
Rejoinder
It is-
also, ma'am.
First written submission.
My
Let him file the written submission. Let him file it.
Your lordship are calling it out 5 weeks.
Then why should so much time be given? Let's count that. Let it be heard on 4th October then.
No, your lordship's initially was praying for 12th. Because
No, 12, sorry, 12.
that will be on the safe zone, my lords.
So both will be in safe zone, 12. So 12 is, okay.
My lords, your lordship will just permit me, my lords, some agreements which could not be filed with the railways and the railway board circular, I may be permitted to file an additional affidavit.
If any.
This matter may be taken up along with 10 and 12 minutes. So these 3 questions, 4 questions will be common for all the 3 appeals.
Right.
Greatly obliged.
I was confused with the category OTA, PLS. I was thinking it is a petition.
Yes, ma'am.
It's a
Okay.
statutory appeal.
Yeah, sorry.
Obliged. my lords.
10.
Item number 10.
Grateful, my lords.
10, my lord. Here the petitioners. My lord, petitioners has applied for on-shop license.
Sorry, on-shop.
On-shop license, my
Okay.
lord, at page 95. On 18/7, 2022, my lord. The application of the thereafter Form 8 notice has been issued. Objection invited. The collector recommended the commissioner also recommended to the government, but the government has rejected at annexure 2, my lord, page 47. 42 on-shop application has been rejected on the ground of violation of provision of existing excise policy 2023-24.
Which
My lord,
what is the policy which is violated?
that policy, my lord, at annexure 1, at clause
An extra one.
relevant page 35.
Sir, what is the policy? I mean, which are the, I mean, the policy, the provisions of the policy or the.
In the policy, they have fixed a criteria that no new on-shop license should be granted in rural areas.
Rural area.
Rural
So
areas.
you are operating in rural area.
In the rural areas, I have applied for.
So if it doesn't suit their policy, they will reject it. What is the problem? You can tell me one thing. If any person similarly placed with you has been granted,
my lord.
then
That
you
is
have
at
a case.
annexure.
Annexure?
Annexure 5, page 92. 56 on-shop license has been granted, but in the petitioner's case, they have rejected. And
But where from this 53 license you know that this is rural area? All are town area. Balesar, Bhadrak, Balangir, Bhubaneswar, Cuttack. They are not rural area as far as I know.
And my lord, here 42 application has been
Sir,
rejected. Some
Tell
of
me
the
one
petitioners-
thing. If any of these list, the licensee, they belong to the rural area?
Yes, my lord.
Which one? Tell me. Which one?
They have mentioned the district's name.
The
But-
district from that, how do you know? How will I know that this is from the rural area? Because the government has a policy that they will not grant any license to the rural area. shop.
My lord, in the similar situated persons, this honorable court already issued notice and tagged
Sir,
the
you
matter.
should notice is different things, sir. I'm asking you the question, you are saying, nah, that part is fine. But the list you are talking about, any of the licensee are from rural area.
Rural.
That is the question you have to
My
answer.
lord, I will file a affidavit on that regard. And as per my instruction, rural areas granted.
Your
like-
instruction doesn't suffice, sir. You have to show something.
My lord, I
You
will
have to
file
show
the
some
affidavit.
document that this is pertaining to rural area.
My lord.
As far as we know, all are cities.
No,
Puri,
they have
Nayagarh,
mentioned only the
Nabarangpur, they are
district's
not
name.
rural area.
No, Jagatpur
Maybe district name, but
Ah.
but you have to show from this we can't
Yes, sir.
decipher anything, whether it is rural area or urban area, right?
କିନ୍ତୁ
So-
ମୋ ଆପ୍ଲିକେସନ ଟା ଥିଲା 2022-23 ର ଏଇଟା
Policy କେବେ ଆଇଲା?
ପଲିସି ଆଇଲା ଆଜ୍ଞା 23-24 ପାଇଁ ଆସିଛି ଏଇଟା
23-24
ହଁ ତ
ତ-
ମୋ ଆପ୍ଲିକେସନ ଟା ଯଦି ସେମାନେ ଅଲଗା ଲୋକଙ୍କୁ ଦେଲେ ମତେ ଦେଲେନି
Just,
23-24 ରେ ନୂଆ
you applied for
22 ରେ
22-23.
ଆଜ୍ଞା।
Policy आयला 23-24.
23-24
Is there any retrospectivity in the policy? Nahi. That's why
ସେଇ ଗ୍ରାଉଣ୍ଡ ରେ ଆଜ୍ଞା ନୋଟିସ୍
if there is no retrospective clause, how can they not be?
ଏମିତି 22-23 already infructuous.
they have extended the period.
Question is not.
But the
Question.
policy for which he, my lord, he has applied for the year 2022 and 23.
Hmm.
In the meantime, that application, that year has already been passed over.
Okay.
It has become.
They have extended, my lord, kindly see
Where they have
Annex 3.
extended?
They have extended
Annex
about
3.
3 months, my lord.
हाँ 3 months ଭିତରେ
Three-
ରିଜେକ୍ଟ କଲେ କେବେ
3 ମାସ ବି ସରିଲାଣି ତା ଭିତରେ।
19-5 ରେ
Yes, you
ଆଜ୍ଞା
notice
reject କଲେ।
along it to hard along with the other things.
ହେଲେ ଗୋଟେ-
Similar case तो ही notice
Yeah,
मैंने
yeah,
सुन
yeah.
रहा
ଆଉ ଗୋଟେ copy ଟା।
At least you should not be disappointed
My
from the
lord,
first day.
my lord.
That notice we issue.
ଆଜ୍ଞା, ଦେଲି ସେ।
Similar kind. Okay, next.
Item 11.
Next is Sam, my lord.
Sam, listen the word. What date was it? Next date କେବେ ଅଛି? ସେଇ ଆର batch ଟା?
Date fix କରିନାହାନ୍ତି। ଆଉ ଗୋଟେ over ଭିତରେ ହେଇଥିଲା।
Let's fix it.
Date fix କରିନାହାନ୍ତି, ଖାଲି
ଆଚ୍ଛା ସେଇ ଲାଇନ ର ଆଉ number ଆଉ ଜାଣିଛନ୍ତି?
ହଁ ଦେଲି।
ହଁ, allow me to do it. Allow me
ଟ୍ୟାଗ
to-
ହେଇଛି।
Tag
20ଟା ଖଣ୍ଡେ ଟ୍ୟାଗ ହେଇଛି।
List the matter on 26.
Well.
Let it come on 26.
Item
You
12.
you have given copy?
Yes, ma'am.
Yes, ma'am.
Mr. Notice. You file your reply, sir. We'll finish it.
Reply has been filed in this case.
In
Those-
this case also
My lord, I will
it will be filed. Because every case is your own facts and circumstances. So how can you say same facts will be applicable here? Law may be the same. Yeah. Next.
Item 12.
Same as item 3. Question is framed at page 7, whether in the fact and circumstance case, the learned IT is correct in law in considering that the
Page
bridging
7, sir?
item number page
Page
7,
7.
whether in the fact and circumstance of the case, the learned IT is correct in law in considering that the bridging fund given by the SSC trust to another society which is not registered. under the-
Bridging fund comes under which provision?
Yes, bridging fund is as per the provision of the Income Tax Act, the funds given with specific
No,
direction.
that I know. What comes under which provision?
And a 12A,
12A. No, no. Bridging fund doesn't come under 12A, sir. Something else. Just check it. 12A, this is charitable.
Charitable, yes.
trust. But the bridging fund for the charitable trust, it comes some other provision.
no, it is written in the
12.
No, no, 12A is, it might have been written, but bridging fund comes under some other provision. You can check. In the 12 only, but provision is not A, something else.
Because since they have taken the registration matter,
Registration is fine. There's a word bridging font somewhere. I've read it somewhere. There's a specific provision for that.
Yes. That has not been mentioned in the definition chapter.
Here we are for the revenue.
Yeah. Let issue, notice may be issued,
Notice has not been issued.
not issued.
2016, I think. 2016 notice has not been issued.
No.
Just it is kept pending.
Yes.
Then must be some.
This has been dismissed. Then again, matter is restored by filing review petition.
Oh, that's right.
Monetary limit.
Okay.
Order has been passed on
Okay.
16/11/2018.
Hmm. Anyway, issue notice. Issue notice to the opposite party. Respondent. 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 Anybody appearing for this?
Yes.
Institution? Who is appearing earlier? Non.
I'll file requisite.
Let him come, then we'll just frame the issue. Question of law. List the matter on 5th October.
Second items, same.
Same. Why the commercial income tax Hyderabad, the commissioner of Hyderabad?
Commission exemption is Hyderabad.
Oh, okay. Sorry. Yeah, this is Hyderabad. Next,
Item number 14,
this is also review.
item 14.
This is also review.
Mr. Federal, defect removed by Monday,
I didn't return.
Item
Copy,
Extra copy is or defect
extra
removed?
no, original copy.
Personal.
You are appearing, who is appearing for this?
I'm for the department.
Okay.
Just now I have received the copy.
So you,
On behalf of Mr. Umesh Chandra Bevra.
Mr.
Umesh Chandra Bevra.
Yes. What is the issue here involved here? Mr. Misra?
Your Lordship, here, even though just now I have received the copy,
Okay.
here the annexure 1 has been challenged and with a prayer to pause that annexure 1. And annexure 1 is, your Lordship, the DRC 07, that is the assessment order under section 73, which is appealable, your Lordship. Without filing appeal, your Lordship, this writ petition has been filed only in order to make condonation of delay. Your Lordship, this order, your Lordship, may kindly turn to page 13. The order has been passed on 14/9/2021. Under GST Act, your Lordship, as per section 107, your Lordship, 107 subsection 4, delay cannot be condoned and Honorable Supreme Court has upheld that judgment. Your Lordship, what is the law on so far as
What is
the,
the total delay?
your Lordship, here the delay is more than 2 years. Your Lordship, delay 3 months, within a period of 3 months, they have to file appeal. And the appellate authority can condone the delay for a further period of 1 month. So, your Lordship, Honorable Supreme Court in catena of judgment and different Honorable High Court, your Lordship, all the judgments I have, your Lordship, in all the judgments, it has been categorically held that Section 5 of the Limitation Act does not apply, wherein a special statute and the upper limit of limitation, condonation of delay, upper period, has been given by the statute. Here, as per section 1074, the statute has given the discretion to the appellate authority that he can condone a maximum period of 1 month. So 3 + 1, 120 days is to be condonation. And your Lordship, in Hon'Ble, India, the larger bench of Honorable Supreme Court has categorically held that delay cannot be condoned. So for that, only for that reason, he has filed this writ petition. Hence, the writ petition is not maintainable at all.
Let it come Monday on behalf of Mr. Umesh Chandra Bevrai.
Let it,
Your Lordship,
we should not be unnecessarily misunderstood.
Your Lordship, yes.
Okay, Monday, yes. Let's matter on Monday. The request of your name, sir?
Manoj Kumar Mahant.
There's so many Manoj Kumar, Mahant, there's a lot of confusion. Let me matter on- Monday, Monday.
Item 15.
15.
Please, my lord. Consolidated petition is filed by incorporating the modified question of law.
You sub copy?
Yes, yes.
What is the modified question of law? By that?
Page 30,
13.
30, 30.
30. Three zero is the order passed by the.
No, no, consolidated petition.
Just. Consolidated. That's right. Oh, sorry. Okay. Whether the facts are in the case. The question, always question of law should be as brief as possible. It's not a very lengthy one. Your sentence is running for 4, 5, 6. The really focus of the question gets diluted. It is focused. Yeah. Whether the facts is whether the case, the order of learned tribunal is legally justified when the learned tribunal has passed the order without. This is not a substantial.
You Lordship may refer me to sort it.
Yeah, this
Your Lordship may
is not
refer
a
me.
substantial question.
If your Lordship is satisfied, then your Lordship may refer me to
The second, answer. This may be one. Like the one consider petitioner has filed a consolidated substantial question of law, which includes one, whether the learned income tax officer commencing an inquiry under section 136, commencing an inquiry under section 136 of the Income Tax Act from the suppliers of the appellant was correct in law to make an assessment before receiving the replies from the
supplier.
To hold that the genuineness of the purchase is claimed to have been made by the SSC could not be verified.
Yes, filing a challenging two order. One is rectification order has been rejected, and the earlier both the order is challenged in the IT. Fourth is also.
Yeah, just repetition. Would take the actually. 1 and 4.
1 and 4 subsection.
2 and 4. यही कथा को बारंबार repeat कर सकते. ITR 4 means there is no books of account.
assessment order
5 टा लिखो. Every short.
थ्रीटा दरकार पड़िबो काहे कि से विदोल्ड कर दिले माने कमिशनर अपील रे भी सबमिट करलेनी ई लॉन्ड आईटी टेबल कर.
ठीक है. The 6 कौन है? 6 तो पूरा आपण क्वेश्चन बने ना आपण स्टोरी लिखि छथि. एमती क्वेश्चन फ्रेम करा जाय. गोटे पूरा लिखि पूरा बड़ा 20 की 25 लाइन. Question framing should be 2 line, 1 line. Very brief. Question precise है तार आंसर तो ठीक है जी. आपण लिखि पूरा ते स्टोरी लिखले पूरा लिखि लास्ट में क्वेश्चन मार्क रे पके देले क्वेश्चन को. एमती हबन. You have to frame it properly. whether
जो reply ଟା receive କଲେ ସେମାନେ ସେଟା
sir,
ତା ପୂର୍ବରୁ
ଏତେ ଲମ୍ବା ହୁଏନି sir. Please, the size should be 1 or 2 lines, not more than that.
133(6) ରେ notice ଟା ଆସିଲା supplier ରୁ ଆସିଲା ତା ପୂର୍ବରୁ ସେ judgment pass କରିଦେଲେ
That's fine, but that can be ruled in 2 lines.
ତାପରେ ଯେତେବେଳେ
Whether
appeal ରେ ଆଉ
whether-
tribunal ରେ ଥିଲା
whether the
ସେଟା
writer is given to justify in
withhold କରିଦେଲେ
resorting to,
submit କଲେନି
the contentions made in the ignoring the relevant matter based on the reporting. You can find out. ଆପଣ ଏଇଟା consolidated କଲେ ସେଟା ଆହୁରି confuse କରିକି ରଖିଛନ୍ତି. This is not done. ଏଇଟା ମାନେ
1 and 4, 1 and 4.
ହଁ
1 and 4.
unnecessary ଏତେ ଗୁଡା ଲମ୍ବା
appeal commissioner appeal ରେ
କିଛି ନାହିଁ ସବୁ ସେଥିରେ cover ହେଇଯିବ. 1 and
All
3
are facts.
1 and 3 unnecessary ଏତେ ଗୁଡା ଲେଖିଲା ଆପଣ facts ବେଶୀ ଦଉଛନ୍ତି law କାଇଁ law ଦେଖା ଯାଉନି law କୁ ଖୋଜିବାକୁ ପଡୁଛି ଆପଣ law ରେ question of law ନା question of law ହବା କଥା ଆପଣ question of law ରେ question of facts ज्यादा ରହୁଛି ସେଇଟା question of law ନୁହେଁ
Substantial, like
substantial question of law.
ITR 4
Let him file the reply. ଏତେ ଗୁଡା କରିବି ସେ ବି he will get confused. He can't understand anything.
It is articulated, admitted, I will reply.
Yeah.
Not required.
Department, the revenue. You file the reply. Within 4 weeks.
Reply is not required.
Oh, sorry,
Appeal,
appeal.
it's appeal.
I'm so sorry. Appeal.
Read or message.
Confusion is. So, written submission, file a written submission.
Not required. Can face of it can be satisfied that there is no substantial question of import in this case. I'm ready, but let it.
Let him get ready.
Yes, yes.
He's not ready.
No, that therefore that.
You just come with a short note of it. That's not any file. I'm fixing it for 4th October.
Yes.
Final day.
Item 16.
May I please? In this case, if I'll take your lordship to the brief of the case, my business premises was visited by a audit team as per the statutory procedures.
Okay.
Audit team visited my premises, and while visiting the premises, they found detect some sale has not been shown in the books of accounts. So they levied an additional tax of, if I will take your honor to page 27, the audit visit report. So they found some 51 lakhs of sales has not been detected, which amounting to rupees 2,32,000 and or the suppression of tax. During the same period, when I filed the return, I had taken an excessive input tax credit to be carried forward for the next period, which was amounting to rupees 2,01,675. So during the procedure, I submitted before the authority, the same may be considered, which I have not taken in the subsequent period as the excess carry forward. So that should have been adjusted. Both the forum before the adjudicating forum as well as in the appellate forum, this was not taken into consideration. If I'll take your honor to the impugned order of the sales tax tribunal at page 47.
Yes.
That is impugned order of sales tax, Honorable Sales Tax Tribunal. Para 6. This is a relevant para. Basically, 2 issues have been brought before us in the second appeal for adjudication. First of all, this is the only which I am under dispute. First of all, the dealer appellants' contentions are that when there was balance creditable ITC of rupees 2,01,600 at the end of the audit assessment, that is
31/3/2013, neither the learned assessing authority nor the learned first appellate authority considered the same for adjustment while demanding rupees 2,32,000 on account of non-disclosure of retail sales worth rupees 51 lakhs and during the period. However, we are not much persuaded by the above-mentioned in view of the facts of the position of law. As a matter of fact, the dealer appellant has carried forward ITC amounting to rupees in its return. This was admitted that I have carried forward. Thus, the dealer appellant is entitled to utilize the carried forward ITC for the year 2013-14 onwards. So this is the other, because the subsequent return, I have not taken that. If I take your to annexure 1 at page 1A, sorry.
Page
18, turning page 18, annexure 1A. This is
you have not explained it fully. This just you read it. Just what do you mean by this?
The amount which I had to carry forward for the subsequent year.
Correct.
And as in the relevant assessment year, I have taken the carried forward. But in the subsequent period, I have not utilized because there was a separation of tax, and thus I utilized the same in the said period, in the prior period, which are under dispute. So my submission was that this carried forward, which was I had not taken in the subsequent period, that should have been adjusted while raising a balance tax demand on me. So the learned assessing officer, what he did, he took that as a carried forward to the subsequent period, but while raising a demand, this has not been considered, and balance what has been asked to demanded, that is demanded. My submission is that if that would have been adjusted in that demand, it would have been reduced to the if in the subsequent return. If I'll take your honor to annexure 1 is page 18, I have not shown that serial number 5 input tax credit carried forward for the previous tax period nil. I have not shown that. So it is that I have adjusted in that amount in the previous year. So I have not carried forward it. So learned assessing officer as well as both the appellate authority, they didn't consider and sustain the demand, whatever the reason, without taking it. That is my submission. If that would have been considered, my demand would have been lesser and the.
Your Lordship, admittedly, demand has been reduced. The additions have been allowed by the tribunal. So far as that addition of sales of purchase separation.
Second issue. Second, I have not.
Let me. So that has been allowed. What happened here, Your Lordship? The impunct period is 1/4/2011 to 31st March 2013. Your Lordship, it is the period for audit, it is the period for assessment. Your Lordship, during the period of audit, this period, he has filed the last quarter return, that is 1/4/2013 to, sorry, Your Lordship, that is the period, the last quarter. Your Lordship, already seen, that is at annexure 1 page 12.
1/1/2013 to 31/3/2013.
1/1/2013 to 31st March 2013. He has disclosed a carry forward of ITC at page 15, that is 2,100,675. This is the impunct period. Because beyond this period, the assessing officer as well as audit officer cannot go beyond this period. Your Lordship, this period is impunct for assessment. If at all, Your Lordship, there is an error, by mistake it has been done, then he has to file, the rule says, the law says, he has to file a revised return. Admittedly, he could not file a revised return because there is a bar. Once audit notice has been issued, you cannot make any voluntary disclosure. Now, Your Lordship, in the subsequent period, what my learned senior says that we have not availed. Your Lordship, once it has been carried forward, means it has to be brought forward in the subsequent period. Even for the subsequent period, Your Lordship, if it is a mistake, Your Lordship, he could have filed the revised return within a period of 3 months, Your Lordship, as per section 33(4) of the Act. Your Lordship, once he has not filed any revised return, no disclosure, no voluntary disclosure can be accepted. And in one stake, he is saying that I have not claimed And in another stake, he has said that it has to be given credit during the impugned period of assessment. During the impugned period of assessment, it cannot be allowed because he has himself, because it is the self-assessment regime. In self-assessment regime, he has to disclose everything. Your Lordship, for a moment, Your Lordship may kindly turn to section 33 of the Odisha Value-Added Tax Act. It is them to file. Only basing on the return, the assessment has to be done. Your Lordship, here,
Section
33. Every periodical returns and payment of tax, every registered dealer shall furnish return in such form and for such period by such date and to such authority as may be prescribed. Your Lordship may kindly turn to 4. If any dealer having furnished return under subsection 1 or subsection 2 discovers any omission or error in any return so furnished, where there is requirement for adjustment of the sale price or tax or both as the case may be in relation to sale of any goods, make such adjustment by way of issue of credit note, debit note as the case may be. He may file the revised return within 3 months from the tax period to which the original return relates. So here, my respectful submission before Your Lordship is that যদি আজি ফ্রডটা ধরা হি নথন্তা তাহলে he could have adjusted in the subsequent year, he could have period, he could have brought forward. Your Lordship, since the audit has been done in the meantime, and in the audit certain discrepancy have been found, so intentionally he has not availed that. If admitted intentionally, he has not admitted. And once Your Lordship, it has been carried forward in the subsequent year, that ITC, that tax is not within the hand of the dealer for the impugned period. That cannot be considered. Only that has to be considered if he has appealed, because it is self-assessment. And if at all in the subsequent period he could not brought forward, Your Lordship, then what can be done? He has to file a revised return because there was no bar for the subsequent period. Subsequent period, a period re ତାଙ୍କର କହିବାର କଥା ହେଲା ଯେ I could not, because I could not file revised return. ଆଜ୍ଞା, ଯେହେତୁ audit notice ହେଇଗଲା, subsequent period ତ audit ନାହିଁ, so he could have filed in the subsequent period. So when he has not filed, and now since the demand has been allowed, now he is saying that it has to be adjusted.
May I please? Yes. May I? My lord, this period relates to 2011 to 2013. My revised return to be filed within 90 days. If I would have filed the revised return, it is to be on June 13. It was falling due on 36, 2013. I would have disclosed. If Your Lordship will see, when they have issued me the audit visit notice, notice was issued on 31/5/2013. So they didn't allow me to file the revised return.
So it was up to June, it was there.
It was there. My revised return filing date is falling due on June 13. So they issued me the 13th. So I did not have the chance to avail whether to file the revised return or to go for the higher rate of 33.4 and 34. So this was when it was detected. I considered to my suppression. I said, you take that excessive amount of it, which I am not carrying it forward for the next 8 years. So they didn't consider. In the other, one way they took the suppression, they didn't take into consideration of my ITC. If that was considered, it was because subsequent period they have not assessed me. Till that, no assessment. So where that fund will go, it is excessive. Till that, they are not refunding it to me. Within 24 months, they have to refund it me. Till that, they are not refunding.
So he can claim for refund.
No.
He can, Your Lordship, that cannot be.
One way you are not allowing me to.
How can it be allowed? No, not at all. Your Lordship, law is very clear.
Law, don't say that a law. Law is saying, if I have to give an opportunity, by end of 30 days, 90 days, I should have filed the database. But you initiated with the audit proceeding within 1 month. So how can I say that I filed the bill? That is not the way. That is not the way you have to do it. So first you give me the chance. First you give me the chance, then I'll tell you.
Before June, I mean, in May itself, you just issue notice.
Your Lordship. Your
Should
Lordship,
have actually allowed it because the time was still June.
Your Lordship,
Yes,
why am
yes.
How can you say that he didn't
Yes.
file, he didn't?
Your Lordship, why I'm saying so? Why I'm saying so? For the subsequent period,
Subsequent till that you have not
Let
assessment,
me
neither
come.
you are refunding. It is provision is that within 24 months, so much they have to revise, return with us.
Okay.
Your Lordship, for the subsequent period, the return has been filed much later. Subsequent period, the return has been filed much later because that is June quarter and it is the July, by end of July, the return has been filed. So your Lordship, in the subsequent period return could have been revised.
Why?
That could have been revised. That has not been revised, your Lordship. And how, your Lordship, in
Why
one,
not?
Try to understand.
your Lordship,
He was, his time was till June.
your
Yes,
Lordship,
yes,
Ah,
yes.
he
your
should have-
Lordship.
13, that might.
Before that, you
Let's
short-circuited everything.
asking me
Okay,
question.
I'm sorry,
let
I'm
me
sorry,
answer.
I'm sorry, I'm sorry.
Yo, what is this?
No, I'm sorry.
You short-circuited before that period is over.
Your Lordship, admitted.
That is a.
Admitted, I'm not disputing that. For that reason, from the very beginning, I have stated that since there is a bar,
Yeah, that was wrong.
your Lordship, but audit, your Lordship, why that is not, because in the subsequent period, he has not brought forward. So my only submission,
Sometimes officers, our alacrity now, it solves kind of problem.
no, I'm,
Just, you should have just, at least you should have waited till that time is over.
your Lordship,
Then
I'm not
can't
disputing that.
blame squarely on him only.
Your Lordship, but
The-
what
the-
happened?
There is a mistake on your part of.
What happened, your Lordship? That your Lordship may kindly turn to the tribunal orders that finding.
Yes, what is the tribunal order? What does it say?
So it is the beyond period of assessment. Your Lordship, the subsequent period, your Lordship, basically that 47, paragraph 6.
Hmm.
Basically, two issues have been shown. First of all, the dealer appellant's contention are that when the dealer is 2,01,600 at the end of the audit period, for neither the assessing authority nor the learned first appellate authority consider the same for adjustment while demanding 2,32,242. Your Lordship, this excessive ITC was not during that input period. That has been carried forward in the return, your
What is
Lordship.
the period for that excessive? item?
That one for 2030. The period for assessment is that
That period.
one for 11 to 31st March 2030.
So the relevant period, how can?
Your Lordship,
That is for the relevant period.
relevant period.
Yeah,
I mean-
That now you are saying not for the relevant period.
No.
Yeah.
I'm saying that for the relevant period, audit
Sir,
assessment.
that was pertaining to that period only.
Lordship.
Then,
No. That is,
if that period is, why can't you take advantage of that?
no, Lordship, that is the
Can you-
period, what my submission.
No, his assessment will reduce.
No, that he has carried forward. Your Lordship may kindly look into page 15.
To be carried forward.
Your
That
Lordship.
is not carried forward. That
Total
wording is
ITC to be carried forward.
To be.
Excess.
That is to
Exercise.
be. That is not carried forward.
Again, to be manner that is to be
No,
carried
no, no,
forward.
No, are
He-
why you?
he's
how
right.
Your
you-
Lordship,
Yeah,
to be,
yeah.
Carried forward and carried forward different.
Wording is.
I have no scope, since that is the input period, I have no
Wording
scope
is to
to,
be carried forward.
I have no scope to look after the subsequent period, your Lordship. Whether it
Now
is,
the question, basically the question is
again,
whether that amount pertaining to this period or not.
Yes.
If it is pertaining to that period, the matter ends.
amount,
You don't have any case.
your Lordship, amount pertaining to this period, what has been carried forward.
So why this?
So amount of 980, mane, what my respective submission, the amount was there. Your Lordship may kindly look into section 21. What is the carry forward method?
Sir, that I know, sir. No need to
Your-
show the
your
provision, carry forward.
After adjustment, the excess input tax credit after adjustment shall be carried forward as an income tax credit to the subsequent tax period. So here, after adjustment, he has carried forward.
Till it is fully satisfied. If you are reading the whole, you say, till it is fully satisfied. I'm asking for the full adjustment.
I'm not denying your Lordship.
Yes.
So what my
If you are
respective-
reading the statute, you read it fully.
Yes, he's right.
My intention is not to have,
No, just.
Your Lordship may kindly look into section 21, again 21(2). The excess input tax credit after adjustment under subsection 1 shall be carried forward as an input tax credit to the subsequent periods till it is fully adjusted, provided that no input tax credit. Again,
What mistake he committed then?
he has committed the mistake
No,
that he has carried forward.
no, it is permissible.
Again, move on. I'm not disputing.
What is the problem?
Again, once he has carried forward, say amount of say period 9. So what my only submission, when that amount is not within that period, so how it can be adjusted against
that?
tax?
Different way only.
Again?
Same thing in a different
Again. So more my submission that since there is no tax during the period, so it has been carried forward. So the assessing officer has no reason to look into the subsequent period because it is the input period.
Okay. Order reserve. Just give me a short note.
Okay.
By tomorrow?
Monday.
Tomorrow. Monday. Next.
Item 17.
May I please? Your revenue appeal filed under 260A.
You also give me a short note. Just small, 1 or 2 pages. I don't want a long note. Very to the point.
By Monday, Monday
or any case law if you have. Yes.
Here revenue has filed this appeal under 260A arising out of the order by Annexure 1 passed by the tribunal, Income Tax Tribunal, Cuttack Bench, Cuttack. The revenue appeal starts on page 29.
So what is the what is the
question of law? Yes, question of law is referred in page 11 of the appeal memo. 2 questions. One is whether the go down has been prepared and by the corporation, whether it's come.
Just 11, no?
Appeal memo page 11.
Yes.
Corporation has invested some amount for a go down, Kindu leaf go down. So tribunal held that it is a revenue expenditure, cannot be capital insult. As your lordships know,
Down is revenue expenditure.
that is what the tribunal held.
How? It is always a capital expenditure.
Yes, it always capital asset, without any doubt. And second question is, the allowing a claim of prior period,
Any infrastructure cannot build.
that cannot be revenue expenditure. That is a capital expenditure. That is even that is an asset in the part of the corporation.
Correct.
That is a standard of the accounting standards 26A. So B
This is a fundamental.
Yeah, absolutely.
Standard. This is a fundamentals of accounting.
Yes.
He's smiling where he has also done studied some accounting.
And it's not yet been admitted. My senior is appearing. Delay has already been condoned.
Okay.
And next is C.
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 So 1 and C.
Yes.
1 and C.
Let it be admitted, then my senior will argue if required.
E and C.
Substantial question 1 and C. A and C. A and C. Yes. You want to say something, Mr. Kar?
Let the questions be admitted. I'll address your lordship.
Yes. Okay. Let's fix it for final hearing.
Yes, yes.
It is again, it's a 2021. Okay. So keep it for final hearing on 11 October.
Yes, yes.
Yes, next.
Item 18.
Item 18, in fact, Mr. Mahapatra, my learned senior, Mr. Manas Mahapatra, was supposed to appear in this matter, my lord, sir.
Is there?
No, he's not there, my lord. He couldn't join your lordships. Because
I'm assisting my seniors in this matter, your lordship.
He
Today
had,
one.
2 weeks after, if your lordship would see, I'll inform him.
What is the issue?
Not issue.
Yes, without opening your file, what is the issue? Just for my
I have also.
refreshing my memory.
Loss in OTS.
Oh, I'm sorry. Because in fact, the file was.
One-time settlement, process in net, and that has been claimed in the expense.
Oh, OTS.
OTS, one-time settlement. Yes.
Sacrificial tax.
In fact, your lordship,
Taking advantage of
so far as the
sacrifice.
NCLT is concerned, your lordships have often heard about that haircut. So we took the haircut in order to get some amount of money to save the institution.
Okay, so that haircut is being taxed now.
That haircut is being taxed, which the NCLT has accepted as a normal also.
Okay.
17 crores.
It's a big hair, long hair.
Rapunzel, we have heard.
So let's hear it on 6th October. Can you fix
Very
it?
well,
6th October?
very well.
Yes,
Finish
yes.
it.
Manas,
Yes,
Manas.
All are issues.
Manas.
2, 3 page, 4 page.
No point in hanging around with
Yeah,
this.
exactly. We'll finish.
6th October.
6th October, final year.
Right.
Obliged, Your Lordship.
19.
Item 19.
In this case, madam, counter agenda, everything has been filed, madam.
Everything is filed.
Yeah.
So both are ready.
Let us fix any date.
Today,
Today is
not a good day. So anyway, when is a good day for you?
Second week of October.
11 October.
11 October.
11 October. For final hearing. Final hearing. We'll finish it, sir. Final hearing, please don't take time for that. Just give me a short note, both sides. We'll finish it. And any case law, if you have any. On this. Case law, I think it is filed already. Next.
Item 20.
May I please, Manas?
20, my lord,
You
there
put-
is there is wanting of my lord, filing of second copy of the counter affidavit.
Okay. You second copy.
Second copy of the counter affidavit. That is a noting
given
there.
me?
No, I have sought to my lord senior.
In fact,
No. Have you given it to Mr.
yes,
Yes, I have
received
sought,
the
my
copy.
lord. I have sought.
What is the issue about?
Now, the issue, my lord, is that so far as the CBDT circular is concerned, I'm challenging an
You're
order.
challenging the circular.
No, my lord, I'm not challenging this. I'm in fact taking aid of the circular, my lord.
Okay.
So in fact,
But you are saying challenging the legality and sustainability
But-
of proceedings initiated under 148A(b) of the Act.
my lord, what has happened, my lord?
But challenging are not taking sustenance. Where is
No,
taking
because
sustenance?
I take sustenance from the CBDT circular, which says, my lord, on the last occasion I had passed 2 copies of the, I think it may be in your lordship's brief, my lords. That's instruction 1 of 2022.
Page?
No, I had submitted on the last occasion.
Loose copy.
Loose copy, my lords. The order also takes note of that. I think that's there in the record minutes.
You have filed the counter also.
I have filed the counter, lordship. May I pray one
What
thing?
is this is the implementation of the judgment under Supreme Court?
No, what has happened, my lord? I take sustenance
Oh, that
from
Ashish Agarwal judge.
Ashish Agarwal. What has happened, my lord?
My lord,
After Ashish,
may I pray one thing, my lord? My lord, in this case, this honorable court has passed the order in batch of cases by remitting the matter back to the assessing officer to deal with the matter, my lord, in Koala's KDS case. In view of the Ashish Agarwal's case,
Same issue.
same
no,
issue.
my lord, here the
Lordship,
issue is
I'll
slightly
bring-
different. I
I'll
would have,
bring
I would
that
have easily, my lord,
Okay, let him.
and
let
I
him
would have
say that.
easily
No, my
agreed with my learned friend. It was a very fair suggestion.
Hmm.
What has happened, my lord, if your lordship would kindly turn to page 7.1, my lord.
No, may I
Paragraph
let it
7.1.
come any other day, my lord? I have not brought the right decisions, lordship, kindly. Any
Kailash,
other.
Just let's.
I'll
My lord,
I'll
wait,
I'll
wait,
just place the
Let's
material
know
on
the facts.
record.
Yes, 7.1.
7.1, my lord.
In that notice.
In that instruction, lords,
Oh, well, that's 7.1. Okay. Honorable Supreme Court has directed.
my lord,
Starts with that.
has directed that information and material is required to be provided in all cases within 30 days. Your lordship,
Yes. Sorry, we have
Thank
only one copy.
I think in the second brief of the that will be there.
Anyways,
So it's a brief test So
please,
may I just place it slowly? I think in the second brief of the because I precisely remember I had given it 2 copies. Notes.
Yes, we got it. It is also here. Scan copy is there.
Manoj. Honorable, my Lord Justice Satpathy has
Yeah,
Honorable
Yes.
paragraph 7.1.
7.1.
Honorable Supreme Court has directed that information and material is required to be provided in all cases within 30 days. However, It has been noticed that notices cannot be issued in a case for assessment years 13-14, 14-15, and 15-16 if the income escaping assessment in that case for that year amounts to or is likely to amount to less than 50 lakh rupees. Hence, in order to reduce the compliance burden of assessees, it is clarified that the information and material may not be provided in case of assessment years 13-14, 14-15, and 15-16. If the income escaping assessment in that case for that year amounts to or is likely to amount to less than 50 lakhs, separate instructions will be issued regarding the procedure for disposing of these cases. My entire case, my lord, is this is so for 16-17. But in the meantime, my lord, section.
So that sorry, the Ashish.
Ashish Agarwal, my lord, what has happened?
This is for what? To the year to
My lord, 1/4/2021, if your lordship remembers, the new provision came forward,
Yes.
which was a reflection of to give a assessee a chance of personal hearing, my lords.
Yes.
And thereafter, 148A, B, C, D, my lord, that was introduced. Ashish Agarwal, my lord, speaks of cases where after 1/4/2021, my lords, notices were issued. Several high courts had quashed those notices because it was issued under the old provision, not under the new provision.
Yes.
So in order to save those 9,000 some odd notices, Ashish Agarwal said that all notices issued after 1/4/2021, even though under the old law, will be presumed to be a notice under 148B of the amended provision. And accordingly, they were asked to file replies. But your lordship would appreciate, so far as 149, there's a limitation is concerned, Ashish Agarwal precisely said that that will be always available. They did not touch it. So they did not go to the TOLA Act, nothing. They just saved those notices. In this particular case, my lord, 149 also provides that if normal limitation is 3 years, my lords. So 16-17, my lord, it ends in 31st of March 2020.
Yes.
So if you have to go to the extended period of 10 years, as per the new law, the amount has to be 50 lakhs, more than 50 lakhs. So that is my humble submission. So for this, my lord, if your lordship would kindly turn to my lord's annexure 3 at page 38, my lords. Relevant page would be 40.
Yes.
Annexure 3, my lord, is a notice asking me to show cause under 148AB. That is page 38, your lordship got it. Will get it, my lords.
Yes.
If your lordship would come to page 40, unnumbered paragraph 4, my lords.
Yes.
There, just 3 lines from that, your lordship would see the
Sri
amount is
Pradyumna
20 lakhs, my lords. Sri Pradyumna Lat so-and-so failed to comply with the summons so-and-so, so-and-so, so-and-so. Your lordship may skip over it. Just on the bold letters, your lordship would see the amount of 20 lakhs, 25,275. Lordship got it?
Yes.
So this is less than 50 lakhs. So my humble contention, my lord, number one, that it is hit by limitation because assessment year 16-17, it should end in 31st of March 2020. So if you say that you will go to the extended period of 10 years, my lord, the amount involved should be more than 50 lakhs. And that is what the instruction says for the earlier years also. Now I file a preliminary objection to this. Notwithstanding the preliminary objection, my lords, annexure 5
Yes.
at page 46. Your lordship got it?
46, yes.
Your lordship would see that information value is 20 lakhs, 25,275. He considers my representation, and all the same, at page 48, if your lordship would see paragraph 5, he says, and at page 48, he also quotes that, my lords, 20 lakhs, 25, at the top, your lordship would see, 20 lakhs, 25,275.
Yeah.
But all the same at paragraph 5, he says, as such, on the basis of materials available on record and in absence of any explanation of the SSC, it is considered that the SSC's case is a fit case to issue notice under 148 of the Act for the impugned assessment year 16-17. The order is being issued after obtaining prior approval of the principal CIT Sambalpur, provided under section 148(8)(b) of the Act. So my humble contention, my lord, is after GK and drive shafts, a particular statutory enactment was done to meet the requirements of GK and drive shaft, because GK and drive shaft, as your lordship knows, is a court ordained principles of natural justice incorporated prior to a proceeding under 148. So that was now, my lord, given way to a statutory enactment after 1/4/2021, enacting page from 148A to 148D.
Yes.
And all this, my lord, was for the purpose of cutting short unnecessary litigation. And that the instruction also says to weed out unnecessary litigation, not to burden the system, my lord, with unnecessary litigations. So a particular limit was fixed. So my contention, my lord, is twofold. One is on limitation, one is on the monetary limit. So if your lordship would agree with me that limitation applies for assessment year 16-17, if 3 years are counted, my lords, it ends with 31st of March 2020.
Yeah.
So if the department says that no, we will go in for the 10 years period, the limitation, the monetary limitation is 50 lakhs. So if your lordship would permit me, I'll just place 149 lot of the amended provision.
Yes.
And I've also quoted that, but I'll place it from the book.
149.
149, section 149. I'll just briefly place it, then your lordship.
I place
149, I'll just place it.
Yes.
May I just place 149?
Yes.
No notice under 149 is a time limit for notice. No notice under section 148 shall be issued for the relevant assessment year. A, if 3 years have elapsed from the end of the relevant assessment year, unless the case falls under clause B. Clause B is, if 3 years, but not more than 10 years, have elapsed from the end of the relevant assessment year, unless the assessing officer has in his possession books of account or other documents or evidence which reveal that the income chargeable to tax represented in the form of an asset, 2, expenditure in respect of a transaction or in relation to an event or occasion, or 3, an entry or entries in the books of account which has escaped assessment amounts to or is likely to amount to 50 lakhs rupees or more. So that was the provision following the instructions, because this provision, my lord, was put into place with effect from 1/4/2021. And this instruction, my lord, is subsequent of the CBIC, and that covered the earlier years from 13-14 to 15-16. So my humble contention that direct
this is for 28/7/2022.
my lord, 11, my lords, and this instruction is 11th of May 2022. So my humble contention, my lord, is now the statute says that this limitation is 3 years. If you go to the extended period of 10 years, you have to take permission from the appropriate authority, number 1. Number 2, it has to have beyond that pecuniary limit. The monetary limit is satisfied. So on their own showing, since the, so that is a simple point, my lord. So going to the,
is right.
No, my lord. In Ashish Agarwal's case, my lord, that has been streamlined, directing.
Here the facts.
Yes, my lord. That is,
And
I have taken.
Ashish
note of,
Agarwal,
but
but
I
I
have
heard it
replied-
would also agree fairly
I
that
replied-
149, they have clearly stated that, I'm sorry, I have not got that decision, but one defenses under section 149, that's the language of Honorable Justice Shah, my lords. The defenses of available under 149 will be always available. Even though they have said that they have saved those notices issued under the old law after 1/4/2021, they have said that the limitation part of it will be saved. So Ashish Agarwal, notwithstanding, my lords, my rights under 149 is saved. And the department does not dispute, my lord, of that part, that on their own showing, on their own, my lord, facts, it's 20 lakhs amount.
Yes.
And in
that
the-
Ashish Agarwal's case, I have not brought, nor my Lord Senior has brought. We have relied on the, in our counter, we have relied on the Ashish Agarwal's case, my lord. Basing on the Ashish Agarwal's case, my lord, it was reopened.
Which paragraph?
Lordship kindly see paragraph in my counter, paragraph 6,
5,
Lordship kindly.
5, 6.
5, 6, yes, ma'am.
The brief is electronically declaring total income of the case was processed for extra return income thereafter. The case was reopened by issue notice. You just,
And more-
just come to paragraph 5 with their counter.
Months. Lordship, you just give me a minute.
Page, I think, running page 2 in the counter.
Running page 2.
Oh my God.
Months. Paragraph 5 months.
5 and 6.
Months. That the brief facts of the above case is that the petitioner had filed a return of income for the assessment year 16-17 on 1/8/2016, sorry, 1/9/2016, electronically declaring a total income of so and so, and the case was processed under 143(1) on 4/11/2016.
In fact, 6 is more important. 6 is,
Month,
yes,
month.
it culminates everything.
That in reply to the amendments made in paragraph 1 of the writ petition, it is humbly submitted that the facts are not fully correct. Your Lordship may kindly mark, and hereby denied. In this case, 4 years from the end of the assessment year has elapsed on 31/3/2021, and the additional Commissioner of Income Tax Rourkela was requested to accord sanction under section 151(2) of the IT Act 1961 for issue of notice under 148 within the extended period of 30/6/2021 as extended by successive CBDT notification so and so. Accordingly, section 148 of the IT Act 1961 for the impugned year assessment year 16-17 was issued on 21/6/2021 with prior approval of the competent authority within the extended time of 30/6/2021. Hence, the allegation of the petitioner is that the impugned initiation of the reassessment proceeding by virtue of issuance of notice under section 21/6/2021 is without jurisdiction and without the authority of law and is not correct and hereby denied. My humble contention, my lord, is
I think your contention is that the reassessment proceeding by virtue of issuance of notice of 21/6/2021, I think they are justified.
No,
Yes,
what has
sir.
happened?
They are Tola Act.
The Tola Act, Ashish Agarwal takes care of Tola Act, but still says that the defenses under 149 is still available. So Tola Act, what has Tola Act done, my lords? It has saved those notices issued after 1/4/2021 under law. Here they have issued me a notice under 148A under the new law. And if they adopt the new law, my lords, Ashish Agarwal will help me in the sense that my pleadings or my defenses under
Let it
149.
come under that same category, we'll hear it.
Sorry.
This is, I think there is
And if
not
you're
different from the batch.
my lord, and if 149, my lord, your lordship would agree that supposing my learned friend says limitation does not apply, my learned friend, my second submission would be the monetary limit.
No, that
The monetary case, your lord, they have
Agarwal's case said, my lord, whatever notices were issued earlier in the view of the old act, that will continue with the procedure adopted. But that limit will not be applicable.
Monetary limit.
That will not be applicable. That is, I will bring the Ashish Agarwal's
Okay,
case.
let
and
it
we'll
come
hear.
together. When it is coming? That matter?
Where?
Ashish Agarwal.
Yeah.
Sorry, the other batch.
the other batch, they have remanded it to the assessing authority.
Assessing authority.
So my humble
The
contention
honorable-
to
this
read
honorable court in batch of matters in Koilaskadia's case, my lord. They
You have the
are,
order.
my lord, I will bring it. My lord, sorry, I could not bring it.
my humble contention, it will be a futile exercise because if your lordships are prima facie satisfied that this is not a case where the proceeding should continue, your lordship need not send me back again to the assessing authority to consider or reconsider that 148AD order minutes.
No, there
Because
is a
this
stage, my lord, where in 148A notice, my lord, where it has been issued. This honorable court held all the issues will be raised before the assessing officer at the time of
Prima facie, my lord,
adjudication of the
my lord,
148
I'll also, my lord,
This thing can.
Yeah, yes.
no,
You
but,
can raise that issue.
no, your lordship would see in one of my cases, and Karnataka High Court, if your lordship would see, my lords.
I know, there's one,
Man-
what is the name? I'm forgetting.
My lord, the name is, my lord,
What is the name? Part of it?
Sanant Kumar Murali versus Income Tax Officer.
Yes.
There's also a Bombay High Court decision where they have taken this amended provision. Not if, my lord, they can't take a stand, my lord, that they adopt the new act and then they say limitation does not apply.
I know because this judge is a very good friend of mine. He keeps sending me all the.
So, In fact, we get really good judgments from many of these.
No, no, he is very good at this tax. So. What is the finding here? It's
The finding here, my lord, that the capital gains initially they said it was 55 lakhs, 0.77 lakhs. But ultimately, my lord, the SSC's contention was that it was 33.85 lakhs. And it was not exceeding 50 lakhs in terms of 149 1B notice. And then 148 for assessment here was the same, 16, 17, as in the present case, my lord. Then they say a plain reading of Lord, may I place it from paragraph 18, Lord?
I'll write the order. Detail.
And
it should not be remanded, but
Lord, may I just
slightly different. With the limit, otherwise other things are there.
Lordship may take note of. I'll cite the judgment of this honorable court.
And small order
KDS case.
And a short order from the Bombay High Court also. May I just pass?
Give it that. So give it a short note. We should clarify many things gradually. Because these are small things that are actually unnecessarily for without distinguishing the smaller feature. You just send to just the send back there, and that will be again months here together.
Your lordships are very correct. In order to avoid all those unnecessary litigation, they wanted to weed it out, and that is why the entire process.
Yeah.
So now, my lord, what they do is they say that we are following the new act so far as Ashish Agarwal is concerned, but we don't follow 149. How can that be, my lord?
Correct.
If you follow the new law, you have to read it along with 149 and the restrictions inbuilt into that.
Yeah.
No,
so it can't divorce.
Said, my lord, whatever the procedure was there earlier.
My friend's client, my lord, has to follow one step. Either they follow the new law or they follow Ashish Agarwal. In both the cases, my lord, 149 has not been divorced, my lord, from the entire proceeding. My lord.
Yes.
My defense is under 149 is saved. And if, along with the note, my lord, if your lordship may permit me, I'll give the decision of Ashish Agarwal also, marking that portion where they have said.
Ashish Agarwal I have.
Malaj. So your lordship.
Give me a note.
Malaj.
A KDA or something else saying.
I'd only request your lordships, my lord, that two lines which the lordships have of the Supreme Court has said that all defenses under 149 is left open.
Yeah.
Greatly obliged. By Monday, my lord, I'll give a short note.
Yes.
Obliged.
Thank you.
Actually, these are small issues. We should decide, and a batch of cases can be solved. And instead of sending there, then they will take.
For that, this honorable court held, my lord. Whatever issues are there, that is the right of the
my learned friend is referring to one decision. Red chilies is the latest in the point. Red chilies says that a writ petition is maintainable.
But again, a lot of
so we will definitely follow the decisions in our favor, even if it's a single line. So I'll just give a note.
Yes, please.
By Monday. By Monday.
They should.
And all these proceedings.
A lot of cases are coming like this also. But limit part, everything you send to this following the assessment.
Yes, my lord. Only just
only my lord, to cut short all these things, the statutory enactments have been made.
Correct.
And that instruction clearly says
again on that again you will go back and that is the purpose. Yes.
They have said, my lord, to weed out unnecessary litigations.
Yes, yes.
Greatly obliged.
21.
Obliged.
Item 21.
21.
Yes, my lord. On behalf of appellant, I am here on behalf of Gautam Acharya, senior advocate.
So what the case, sir?
Yeah, this is a appeal.
Copy has not solved. Copy has not.
Please serve a copy on Mr. SATAPATHY.
Copy has already been served, sir.
No. If sought, kindly I am request another copy.
Can you serve another copy?
Yes, yes, sir. Yes,
so let him go through that. We will serve some
next week.
Yes, next week. 25th.
Okay.
25th September.
22.
22 may please. In the
22,
last,
before my learned friend begins, my lord, I just pray for a copy of the second sub-item, that's 5 of 2023.
no, my case something different.
Yeah,
Let
this is
me, let me
22,
place, hi, let me place the case, then if required, I can solve a copy. Here, the first item 53 of 2022 has been filed by the revenue, challenging the deletion of the penalty. And the question of law has not yet been admitted. And the petitioner on earlier date stated that the,
So what about the one order passed by Justice Javeri in 2000? What is this in this matter? That is a order of 10
Here.
for 2019. That was
in this case,
it is set aside the same file.
no, here, no, it is fresh matter, 2022 matter.
What is the party name? This is ITA number 13, huh?
No, ITN number 53.
Oh, that's it's not loaded. Oh, I see. Sorry, sir. That was decision. I thought it was the opening of the case.
Here I have revenue and challenge the order. Yes.
Let me open it because a lot of decisions are initially put and then the appeal starts. Yes.
In the 53, in the last order, I have submitted that the original order has been challenged by the revenue and it is pending for adjudication. Therefore, the penalty proceeding which has been quashed by the tribunal is illegal because the quantum has not yet been finalized. Therefore, the penalty issued under section 271C is not permissible. That is the issue. Then this honorable court stated that that may be tagged 5 of 2023, the original order basing on which the penalty has been levied. That also challenged before this honorable court. So before that, I am requesting Lordship kindly see the 5 of 2023.
I just request my learned friend for a copy, my lord. What has happened
Yes.
in this case?
Let it admit
The
it.
first, no,
There for the
It's not even admitted. First time.
What has happened, my lord, in this IT 53 of 2023, for which a copy has been given, it only challenges the penalty levied without challenging the quantum assessment. Now my learned friend says that he has challenged the quantum assessment in 5 of 2023. So that's why your lordships on the last order, 4/8/2023, if your lordship will kindly peruse. 4/8. There my learned friend was asked to serve a copy of 5 of 2023 on us.
You give a copy.
And I see, I'll just.
So let me be served with a copy. Your lordship may call it next week.
Lordship may admit this appeal.
No, your lordship may
Because
call it
both the
next
appeal
week.
is-
Let me go through
both-
it.
Let him go through it. We can fix it on
Yes.
Next week or so.
next 26th for this.
Yes.
26th. Let him go through.
Ah,
that we
yes.
can-
No issue.
26th, huh?
Yes.
Obligement. September, huh?
Item 23.
Put a copy, baby.
What up? Ready for hearing?
Item 23.
Yes. You ready, sir? This is
Uh,
the final hearing, I think.
My lord, I have a preliminary objection to this. The appeal is not maintainable in light of the monetary
At
limit.
the final hearing stage.
I was not there in the on the last date, my lord.
No,
when the-
this has been finally fixed for hearing, I think. Let's see the order. That should have been done at the initial hearing. Why it is not maintainable?
Because of the monetary limit fixed by the board,
Oh,
it has to be 1 crore. In this case, it is only 64 lakhs, my lord.
okay.
No, not 1 crore, it is 50 lakhs. Maintenance is 50 lakhs.
No, these are already amended.
Somewhere that notification you had in the order, it was there somewhere. Sir, all these, the question has been framed, everything has been done. At this stage, you can't say, I have no objection.
Actually, if
You argue the matter?
your lordship will kindly go through the order, last order itself.
I have gone.
There the lordship has categorically recorded that I was not there. I just entered my wakalatnama, that's all.
Okay, then you argue it finally. Even with that objection, we can take it up.
Can I be given few days more?
You want to argue for, okay. Let him. Can it be 3rd October? 3rd October, you have any problem?
4th will be better.
4th, okay,
Yeah.
4th.
4th October.
Okay.
Yeah.
Let him come prepared and give a note also.
I'll do that.
Whenever we are,
I'll do that.
give a note so that we will be very helpful.
Term number 7.
7?
Yes, my lord. In that, my friend had filed an affidavit of 76 pages. He served me copy on 5th only. I could not take instruction. Lord.
Okay, let it come on some other day.
Next week, my lord.
List the matter on 22nd.
Pardon, my lord, my lord.
क्या करें? ସେତେ କନସର୍ନ ଥିଲେ ତ ଆଗକୁ ଦେଲିନି କପିଟା ହେଲା ଯେ କପିଟା ତ ତାର ଲାଷ୍ଟ ମୋମେଣ୍ଟ ଦେବେ କେମିତି ହବ?
76 ପେଜ ର
ପଢିବା
5
ପାଇଁ ଟାଇମ ମୁଁ ବି ତ ପଢିବା ପାଇଁ ଟାଇମ ମୋତେ ବି ଦରକାର
କୋର୍ଟ ରେ ଦେଇଛନ୍ତି ମୁଁ
ଆପଣ ସବୁ
ପଠେଇଛି
ଲାଷ୍ଟ ମୋମେଣ୍ଟରେ କୋର୍ଟରେ ଦେବେ ବୋଲି କେମିତି ହବ? You have to so what? When you are filing something, you must give him a copy.
ହଁ 2 ଦିନ ଛୁଟି ଥିଲା ଆଜ୍ଞା so I could not take
Let him take. କଣ ହେଲା ଏତେ ଦିନ ରହିଲେନି ଆଉ 10 ଦିନରେ କଣ ହେଇଯିବ? 25th ରେ ଆସ।
Lordship.
25th ଆଉ କେତେ ଆକୁ ନେବି? ଆଚ୍ଛା ତ ଆଉ କିଛି ମ୍ୟାଟର ନାହିଁ ତମ କେସ୍ ଗୋଟେ ଅଛି ନା 25th କହୁଛି 25th କହୁଛି ପରା
Lordship, one WPC 1416 of 161 of 2021 order is as per the court direction, written note argument filed.
I may pardon.
Obliged, Lordship.
Item number 2, it will be taken next week or 2.
Item number 2.
My lord.
You are for the petitioner?
My lord.
Okay, I'm the matter on 29th. सर ये ଆପଣ ମ୍ୟାଟର ମଝିରେ ଚାଲିଲା ବେଳେ ଆମେ ପାର୍ଟନ କଣ ରିଜନ ଲେଖିଛନ୍ତି ତ କଣ ରିଜନ ଲେଖିଛନ୍ତି ତ କଣ ରିଜନ ଲେଖିଛନ୍ତି ତ ଲିଷ୍ଟିଂ ପାଇଁ ତ ଲିଷ୍ଟିଂ ତ କଣ ଇସ୍ୟୁ କଣ ଇସ୍ୟୁ
regularization of the GRS.
ସେଇଟା ଗୋଟେ କୋଉ ଅର୍ଜେଣ୍ଟ ମ୍ୟାଟର ହେଇଗଲା ଏଟା ଅର୍ଜେଣ୍ଟ
May I please, your lordship?
in 3
Item number 1.
oh 1
Petitioners became successful in the OTT test, lordships.
What is the issue?
The issue is, lordship, she became successful in the OTT test.
The successful part fine.
Contention, lordships, her name was published in the serial number in the eligibility for appointment. Then as a trained candidate. Then thereafter they reflected another notice by saying that she is in the untrained category. So they are against that we challenge before the Honorable High Court. We failed in the before the Honorable High Court because thereafter we filed a writ appeal. Writ appeal, Honorable Court granted stay. Thereafter directed us to file a representation. In view of that representation, since that representation is pending, lordships,
ଆପଣ କଣ ପାଇଁ ଆଜି ଆସିଛନ୍ତି କୁହନ୍ତୁ ମତେ
ଆଜି ମୁଁ ଆସିଛି ଏଇଥିପାଇଁ
ରିପ୍ରେଜେଣ୍ଟେସନ ଟାକୁ
ନା ମୁଁ ରିପ୍ରେଜେଣ୍ଟେସନ କଥା କହୁନି ମୁଁ କହୁଛି ଲର୍ଡସିପ୍ସ ସି ଯେ ବିଇଡି କ୍ୟାଣ୍ଡିଡେଟ୍
ଆଜ୍ଞା ମନା ନାହିଁ କରୁନି ମୁଁ ବିଇଡି କ୍ୟାଣ୍ଡିଡେଟ୍ କେତେ ଥର କହିବେ ସେ କଥା ମୁଁ କହୁଛି ଆପଣ ଆଜି କଣ ପାଇଁ
ଆଜି
କଜ ଅଫ ଆକ୍ସନ
cause of action since 2019 there is a notification BD candidate shall be treated as a trained candidate. I should be given that they rejected that's kindly lordship kindly come to page
ଆପଣ BD candidate trained candidate କରନ୍ତୁ ବୋଲି କହିବେ ଆସେନି BD trained ନୁହେଁ କି
they rejected. Lordship kindly come to page 26, lordships. That's a untrained candidate. The on page 28 is the
ଆପଣ ଯେତେବେଳେ ଇଏ OTT ପାସ୍ କଲେ ସେତେବେଳେ ଟ୍ରେନ୍ ଥିଲେ ନା ଅନଟ୍ରେନ୍ ଥିଲେ
trained BD. Page 24 my list was 119 as BD candidate 119 for eligible for appointment of the Shikha page 24 lordship kindly come to
ଆପଣ କୋଉଠି BD କରିଥିଲେ
BD that is recognized BD ମୁଁ କରିଥିଲି
ମୁଁ ପଚାରିଲି ରେକଗ୍ନାଇଜ କୋଉଠି କରିଥିଲେ ଆଗ କୁହନ୍ତୁ
Magad University, Bodh Gaya.
Magad University, Bodh Gaya. What
page 13.
Magad University. मगध यूनिवर्सिटी कले आपण
आगे लॉर्डशिप
अच्छा ये
फर्स्ट क्लास
फर्स्ट क्लास कौन पे ताले कॉलेज है बोलो
And here the rate is not maintainable as because Shiksha post is no more. Shiksha post is no more. Now he is claiming post of Shiksha. It has been already repealed since 2019.
abolished
Yes.
but
Junior
he-
teacher
but-
engagement rules.
but he challenging the particular recruitment जो
particular
जो what do you call
way back 2017 रे order ହେଇଥିଲା ତାକୁ he remained silent after 6 years now he filing this repeats.
कौन order ହେଇଥିଲା
Liberty to approach the authority.
अरे liberty to
लॉर्डशिप काइंडली कम टू दैट
ताको order बोले मु कबे ग्रहण करे
लॉर्डशिप काइंडली कम टू दैट
liberty to approach the authority वाला वाला approach तापरे से approach authority कबे देला तार एजाय consider करे
Lordship's order was passed on 7/2/2017 by this honorable court. 10/2/2017 I filed representation. Till now it is pending.
In case all the posts of so and so have not yet been filled up, one post in it and top of final.
It has state.
After some argument were advanced by C.
one post तो बड़ा विचित्र है one
He
post
made a
they keep
request
it
that
one
the
post.
appellant may be permitted to withdraw this appeal with liberty to approach the appropriate authority for redressal of arguments. This is the order passing it. Now on the basis of this order, he is claimed.
Again you are challenging what then
I am challenging in not observing me on the post, Lordship.
को order को challenge करछंदी
In view of the 2019 government notification, they are not taking me till now.
सर आपण ता पई पर आसिले थोड़े आ फाइल करी गले तण गले सेठी आपण
My representation has to be given effect. Lordship kindly come to that they are
representation 2017 रे पेंडिंग
still now it is pending. Kindly come to page
आउट representation मु आउट representation क्लियर कर बोले देबी का लगाओ litigation एटा
Lordship
litigation
Lordship kindly come to page 38. They are not.
अरे सर प्रेजेंट कोन करबी पेज दे जाई गरी मोर पेज दे कोन करबी एटा आपण तो किसी केस रे किसी माने नाही
मु कहूची आज्ञा मु बीडी
आज्ञा बीडी जे कर देले बोले आपण चाकरी दे देबे
ना मु एलिजिबल
हे गेले भी हे गेला चाकरी दे
eligible more trained eligible BD Lordship trained eligible they first issued notice by saying you are a trained eligible in
now you answer
Mr.
Mood you answer one question when you was trained graduate why did you publish his name in the category of trained graduate forget about your post abolished not abolished I'm on the question of your conduct
prayer in the
forget the prayer even forget the prayer no my question is when he was trained why you have not published in the trained category
that part I will
you take
to page 25
even if the post is not there that person is abolished I'm on your conduct how could you not publish and even not publish there must be some reason answer the reason okay yeah Lord Counsel the state to take instruction as to why the petitioner's name did not reflect in the category of trained graduate rather it was reflected in the category of untrained.
First they took me on trained category, then they took me in the
okay untrained category. Though the petitioner has already filed a representation before the authority, and the authority is setting up the said representation for the last 5 years, which constrained him to approve this code again by way of another reputation. Release the matter on 29th also. To take instruction on what? Why somebody's name is there? Your mistake.
the equivalent certificate they not use something else.
Sir, कौन बोले like trained graduate 12 certificate देला तो 12 certificate ना देला बोले काटिबे trained बोले किंदी untrained बोले किंदी कहिबे
जो certificate
sir 12 class रे basis रे trained untrained decide कराइबे I think B.Ed basis रे हबो किमा city category रे हबो okay actually litigation आपण ये create करछन किछ next
item number 3 may I please lordship
से लोकटा भी से लोग से जदी से ए क्वेश्चन कराई कि तमे इंस्ट्रक्शन मगाई कर दिया जाय थांदा दिस वे दैट वे क्लियर ही थांदा 5 वर्ष आ झुल न थांदा से ए रिप्रेजेंटेशन रो ए होची तार रिपरकशन एया रिप्रेजेंटेशन डिस्पोजल दिस लॉलीपॉप डिस्पोजल
true
pay the money to the petitioners who are the legal heirs of Banshidhar Naik, the depositor in the opposite party bank, my lord. My lord, the opposite party.
So you have deposited in the,
Pardon, my lord?
you have deposited with which bank?
Odisha State Cooperative Bank, my lord.
Odisha State Cooperative Bank.
My father had deposited, my lord, some amount. After his death, we are the legal heirs. We claim before the bank that we are the legal heirs. Kindly disburse the amount in favor of us. But the bank refused on the ground that there is a nominee who is the opposite party number 3.
Who is the nominee? Nominee key?
One of the son, my lord.
One of the son.
Yes, my lord.
So you all are,
We all are other sons and daughters of late Banshidhar Naik, the depositor, my lord. Another elder son is the nominee before the bank, my lord.
so
Bank,
that son is,
yes, my lord.
who
Bank,
is the nominee of the son?
bank refused our application on the ground that nominee is the trustee of that bank account, so he is entitled to receive the money. Our contention is that, my lord, nominee, yes, it is right, he is the trustee, but he's not possessing any succession rights to accept that money, my lord. That's our contention. Bank refused our application, and Annex 3 is the.
Who is the bank?
Odisha State.
Anybody appearing? No, no. Who, I am asking who won Odisha? Who won it? Key appear good. But I didn't say what is the bank.
Yes, ma'am.
What is Odisha? I say who is representing the bank?
I don't know.
Ah,
Notice has to be.
notice. Keevada chilla open number
1 and 2, my lord.
one Congress managing director की काम है
2, my lord.
two
is the-
ना
Yes, my lord.
managing director को लगा सब केस deal करेंगे 2 and 3 you should notice to by registered post returnable on 9th October है ना 9th October
My lord, I filed an IA. If
I
there
for
is-
what
I for to not to disburse that
Okay,
amount.
in the meantime the banking of the OP number 2 is directed to not to disburse the amount to OP number 3 है ना
Yes, my lord. Grateful.
so ଆପଣ अच्छा ଗୋଟେ hold on ଆଉ ଗୋଟେ ଜିନିଷ ପଚାର ଭୁଲି ଗଲି here the real heir or
Yes, my lord.
fictitious
No, my lord.
real
Yes, I will file the legal aid certificate.
Okay.
The petitioners
post
have
number
already
କଣ
applied
ଅଛି?
the legal aid certificate.
ବହୁତ ସମୟରେ କଣ real ଅଲଗା real
No,
ମାନେ
no,
ଥାନ୍ତି
no,
ତ ଆସିଯାନ୍ତି
No, no,
ସେଥିପାଇଁ କହିଲି you know some other real also there
Yes, ma'am.
ତାଙ୍କ ଆଉ କୋଉଠି
No, my lord.
ସିଧା ବି ଆସିକି claim କରନ୍ତି ତ ସେ କଣ ପଚାରୁଛି they can also get claim it's not
Yes,
that they
my lord.
can't
But these petitioners are real sons and daughters.
okay ठीक है
Grateful.
next
Item number 4.
Yeah, please, your lordship. I have challenged the order of disengagement annexure 8, your lordship.
disengagement from what sir
GR,
detail
in the
ଟିକେ
post-
କହନ୍ତୁ
The post of GRS, your lordship. While you have.
ଗ୍ରାମ ରୋଜଗାର ସେବକ
Yes, ma'am.
କଣ ପାଇଁ disengage ହେଲେ
That is, they have, on allegation that they have, they have recommended release of payment on government directed such and such with the non-eligible candidate
ଆପଣ
beneficiary.
non eligible beneficiary କୁ କଣ ଦେଲେ
Dog well, implement of dog well, କୁଅ ଖୋଳିବା ପାଇଁ।
ଗ୍ରାମ ରୋଜଗାର ମାନେ ଆଚ୍ଛା ଏଇ ଯୋଉ
Yes,
MNRG ରେ
yes.
କୋଉ
Yes,
ଖୋଳିବା ପାଇଁ
no,
ଆପଣ ତାଙ୍କୁ ଦେଲେ ତ ଆପଣ basically you recommend the name yes
No, I am not recommended. You kindly see your lordship annexure 1.
no forget the annexer sir
I have no responsibility.
just I'm asking some
Yes,
simple thing
yes.
who recommends first let's see.
First, your lordship,
କିଏ recommend କରେ
Sarpanch first recommended the name of the beneficiaries.
ଆପଣଙ୍କ ରୋଲ କଣ
I have role only to verify the document. Only document verify.
ସେ ଲୋକର document ଠିକ ନଥିଲା
ଠିକ ଥିଲା।
ଆଉ ଫିର ଆପଣଙ୍କୁ ଆମେ ମାନେ କଡା କଡା ତାହେଲେ
I have misappropriated the government money and allotted the ineligible candidate. And I have not a responsible.
he is not eligible he is not the person who can make recommendation then how he can be held responsible
And here,
no I'm asking a simple question if the recommendation to the power is that is vested with the sarpanch the recommendation power how can the poor gram rozgar sabab will be held responsible for that
and GR, the duty of the GRS is to execute the MGN SRS work and other.
Sir,
Again.
work part is not a problem. You see, here, suppose some beneficiary to get a bore well, well, digging well, whatever. He has to, I mean, just recommend the name. He is not the person to recommend the name.
No, here the order, impugn order itself says. Sanjay Kumar Sahu, GRS of the said GP, as the person has geotagged the excavation site of the dog wells and recommended for release of payment. Government has
Who
that,
recommended for release of payment?
this GRS, concerned petitioner.
See, payment release kariyo.
At a local to be jaitila. And local.
अरे रोहन सर मोटे बुझे टे के वो बुझी नहीं सब अपन जानी चंद मोटे जानी नहीं ना आई एम लर्निंग यस मो कह रहा था ला रेकमेंड करिया पावर कहारो मोटे बोरवेल टे खवा गारे सपोज माने गोटे लोकर कार
स्कीम गुड़ा जा हुए ग्राम सभा रे प्लेस हुए ग्राम सभा
रेकमेंडेशन यार किसी रोल नहीं
गोटे बेनिफिशियरी
यार रोल कौन
ये सब जाक डॉक्यूमेंट वेरिफिकेशन करी सब जिंस करिवे सब जीआरएस रो मेन रोल
वेरिफिकेशन करके पठेबे तो आपण वेरिफिकेशन कर ले
No, I have not sent the document. Document was sent by the BDO to the DRDA.
नहीं
will-
सर वीडियो पाक तो नहीं दिए थे आपण
मतलब
आपण तो वीडियो पाक तो से डॉक्यूमेंट नहीं दिए
No, I have not sent the PO has sent the document to the DRDA. Panchayat Extension Officer.
यार
तांको नार भी हेची
That is only
sir not on that what is his role I want what role he played
से पार्ट मो से जो गाइडलाइन नहीं आछी एमजीएन
तार रोल टा कोन कहले तार लोग से लोग रेस्पॉन्सिबल हबो ना हबो जाना पड़ियो आ जणा लोक नथिबो कि तार आसपास तार किछि रोल नथिबो ना कहबो ना जे लोकडा एंदी कर देला
जियो टैगिंग से करूछंती
सर जियो टैगिंग इज अ डिफरेंट थिंग व्हाट जियो टैगिंग रे कोन करन दिसने
जियो टैगिंग कर सेटा जो तांकर जो वर्क्स जोटा होउची ए मानकर हला जे माने तांकर डॉक्यूमेंट को वेरीफाई करिवे फील्ड सर्वे करिवे अलोंग विथ पीओ एंड द जेई कंसर्न तापर रेकमेंड करिवे रेकमेंड तापर मास्टर रोल
तो ये कोन करियो ये बेसिस से बेसिस रे तांको नेई कि से जागा को जीवो
मास्टर रोल
जेई बाहा करिवो मास्टर रोल प्रिपेयर करिवो ठीक अछि सेटा मास्टर रोल कला वाले तापर
समस्त को आगे ऑलवेज हेल्ड रिस्पांसिबल
अरे केमती तांको रोल टा कहबे ना रोल टा कहबे ना आपण जदि गोटे लोक रोल नाही सेतरे माने डायरेक्टली इनडायरेक्टली संपृक्त नहे ताको केमती आपण चाकरी बाहर कर देबे
फर्स्ट टाइम आई सी इंस्ट्रक्शन मन यासी
टेक इंस्ट्रक्शन लर्न काउंसिल स्टेट टू टेक इंस्ट्रक्शन
but here let him file the legible copy of the documents
okay file legible copy and learn
I have already filed the
related to file the legible copy
I have already
of the document which is not legible okay next देखिए कौन सा प्लान ऑन करते
I filed
सर आए कौन करबी
stay the disengagement.
एगला डिसएंगेजमेंट ना तो अकाउंट स्टे करी देखो ही सैलरी अकाउंट स्टे करी
They are now going to be fill up that post.
अरे सर जस्ट मी डिसएंगेजमेंट ही चलते ना
Yes, ma'am.
इसे पोस्ट बाहर जी
No,
एडवर्टाइजमेंट है नहीं
No.
आए तो संग रात रात 4 दिन 5 दिन कर दे हां पीछे मत डोंट वरी आसो मैटर 18 रे आसो 18 है ना
stay सब सही दिन पर
हैं
only stay सही दिन पर
अरे स्टे की स्टे देबी कहां पर स्टे देबी से लोक चाकरी नहीं चाकरी थिले हां चाकरी तो ताको काढने बोली देबी की स्टे देबी ऑलरेडी चाकरी बाहर अछि
that is disengagement.
सर डिसएंगेजमेंट माने कोन चाकरी तो
already-
काढी साइलेंट जाकू अकाउंट अटकेबी थोड़ा तो दिमाग लगाओ भाई
and there is provision of
Person
appeal provision state government is there.
अपील पेंडिंग अछि
ना appeal provision अछि
No, no, appeal.
ए रो पचारा ना एते काहे भीतर अपील बोल जाउ छो आसी जे तो कर दो ऐसे कर आ अपील पुनी जो ताको बटे दो से पुनी आउट राउंड बोली के आसीबो
state government is
एठी डिसाइड कर दो किछि अपील कर आसी देखो ए स्मॉल पीपल दिस पीपल शुड नॉट बी unnecessary बिना कारण काढिया कथा नहीं
That is the unnecessary one. You will
Right,
not- That
right.
is selection process is there. How the person, a beneficiary will be selected. That I have annexed the
We'll see,
document.
sir. Let him take notice. When the court is with you, na. ठीक है चुप पड़ रही मुझे कौन सी तो आनंद तू दादा देखिए next
Item number 5.
let's matter on 25th 25th किसी वाले ना वो इधर एडवर्टाइजमेंट बाहर करने किसी इतने संग संग रात रात कर दे
They have proceeded to-
अरे किसी वाले चाड़म एले भी कॉल है ला कौन टाइम
not to engage with the.
not to engage in the order में पास करेंगे Entire process can't be stalled for you only.
No, no, only
Ah.
that course. So far as
No,
fixed
no,
salary
no.
is concerned.
No,
So far as fixed
let
salary
it come, sir. Next.
But in this case, the petitioner prayed for his release of his salary, since he is not getting his salary since February 2022 till date.
Item
5.
Ah. Paula,
Since February 2022 till date, he is not getting his salary, my lord.
what is he doing?
My lord,
My lord, you can say, man.
in
Not
this-
salary, not getting salary.
in
Ah,
this
sir,
case, I
February
got
2000
instruction. Here there is allegation of misappropriation of some fund.
ସେ ଲୋକ ଚାକିରି କରୁଛି ନା କରୁନି ମତେ ଫାର୍ଷ୍ଟ କୁହନ୍ତୁ ବସ୍
Yes.
ଚାକିରି କରୁଛି ନା ମିସଆପ୍ରୋପ୍ରିଏସନ ଚାକିରି କାଇଁ ଅଛି ତ ସେ ତ salary ଦେବେ ଆଉ
That amount will recover. First thing. Second thing, Gram Panchayat is the authority to pay the amount. Here the video has already written to the PO of the concerned Gram Panchayat to pay the area salary if any, area amount. But as because the fund is not available with the PO, he said that if we'll arrange the fund and we'll pay.
କେମିତି ଦେବ ଆପଣ ଜଣେ କାମ କରି ତ
You
ପଇସା
may
ଦେବେ ନା
issue
ଆଉ।
notice to the Panchayat concerned.
ଆପଣ ଜଣେ କାମ କରିছে ପଇସା ଦେବେନି
ସେ ଦେବା କଥା ଆମେ ଦେଖିଛୁ, we have already written.
ପଞ୍ଚାୟତ ଦିଏ ପଇସା
ଆଜ୍ଞା।
ଆଚ୍ଛା ଦେଖ
Actually commission जो sell हुए, sell of commission
petitioner who is working as Yugan Sayak, Gangaraj, JP, Kuliana, bracketed Chandua, in the, under Mayurbhanj block, district Mayurbhanj.
Okay, ready.
Is constrained to approach this court for releasing the salary since the month of February 2022 till date. Lord Council for the state is given 1 week time to take instruction for instruction regarding the reason for non-release of the fund to the
We got
petition.
all your instruction with me.
So what is the instruction? तब पैसा कहीं देले नहीं अपना
पैसा आम देबुनी, पंचायत देबे। पंचायत देबो।
पंचायत रा फंड है कि
ये जो सेल है जोटा तकर
ओके इस आज भी मतलब बता इंस्ट्रक्शन कर दिया इशू नोटिस है थी क्या नहीं फर्स्ट टाइम
नहीं सर 3 times or third
Please जाइए पंचायत में।
who is the सरपंच देखो issue
Four.
notice to सरपंच authorize issue fresh notice to सरपंच and BDO है 3 and 4 OP number 3 and 4 author fresh notice कर दे
so current salary at least
अरे सर करंट से लोक जिनस आसे लोक आइले
या कोन ही
गुटे सैलरी करंट सैलरी मो जंदी धरि के बसी दे देबे एमती हुए लोकटा जाऊ सेठी कोन से कहू देखाय से लोकटा नोटिस ता जाऊ त कम से कम नोटिस आसीनी आउ थरे फ्रेश नोटिस कर जेते 3 and 4 हला
3 टा तो सर से मैंने अपील करते
3 year appearing
हां
yes
सर
सरपंच
का नोटिस है
issue notice to सरपंच issue fresh notice to सरपंच है ना सरपंच OP number 4 okay next notice the matter on 3rd October next
Item 6.
My lord, item 6 on behalf of the Umakant Bari, he is not feeling well.
what is the case sir
The bail application.
bail
My lord.
ganja
302
302 okay
in this case your may call for a report from the trial court regarding status of the trial
okay from the report trial 6th October next
Item number 8.
7 here
Adjourn.
oh 8 Arba 8
Item number 8.
Arba
I filed caveat petition there, my lords. They sought the copy on 5th.
you are for the
I'm for the respondent. I filed a caveat petition. They served a copy on 5th month.
I have served the copy. What I'm saying is that the execution is moving. I'm ready to deposit according to section 36. Anyway, we will not be in unconditional stay. So I'm ready to deposit. I have only one point, in fact, in this matter is that we really basically, though we filed pleading everywhere, there was this one escalation claim which the arbitrator has allowed without considering the contractual provision. He just did not discuss
No,
the
but see,
contractual provision.
Mr.
So also the same problem happened even
Just a
in the
minute,
34th
just a
court.
minute, I
So
request my
all-
sister, that is the limitation.
No, wait. There is a limitation of only 15 days. And we just want to forward the certified copy.
So it is within time.
15 days dairy hai ji. So
15.
that even that certified copy was
15
not done, we're
days,
giving the
so
certificate.
Here.
15 days. There, so there's no question of any section 5.
Okay.
And I'm just praying for a stay and we'll deposit the money in the lower court. Before the commercial court where the execution petition is pending.
Yes, you want to say something?
No, madam, I've not gone through that. So on 5th itself, but my sister says that she is to deposit all that money, the total decretal amount there of the commercial court. Let them deposit it, let it be kept in the interest bearing account. Maybe taken up any day, my lords may fix.
And so that the execution can be stayed, otherwise they are moving in the execution.
Urgent to.
Yes. Your lordships will
that
find,
means-
your lordships will find
31.
IA is 30. 30. That 30.
That the award that passed on 17 2019. Judgment that is 18.5% upon payment of the difficult amount.
Award amount.
Kete din vitre?
1 month.
To pay one.
PSU, it takes a little time and it will go to Daman Jodi, not even corporate.
Daman Jodi, the corporate office decides.
No. But the fund, it is separate. If it is Daman Jodi, then the money will come from Daman Jodi. If certain arbitrations come from the corporate, then.
Decretal amount.
Decretal amount includes interest also.
No, not in. We'll just do the decretal amount.
Decretal amount. And the said amount be kept in the interest bearing account, where money will go west. For the commercial. Commercial code, which commercial code?
Commercial code, Bhubaneswar.
Commercial code. That's all.
May I premiums it will a short date may be fixed month so that it can be taken up for hearing also.
Yeah.
Because it is a copy like
32 ta kon. 32 each.
But one is section 5 and one was that exemption. When we filed it, a certified copy was not there. We've just forwarded the certified copy to the. And the limitation is only of 15 days, if that can be. allowed.
my lords control. My lords, according my objection, my lords may control.
Certified copy you find out.
About he deliver.
You filed it, no? You filed it. Let the certified copy be filed. Accordingly, we'll learn with the petitioner, the appellant, is ready with the certified copy. We have the said copy be filed with the registry. Accordingly, the IA number 31 disclosure. Okay, let it come on. November.
So to delay, my lords,
Full-
my lords being taken up in
Sir,
October in the month of October.
Your thing is secured, money is.
The money is secured, my lords. That involves two parts, my lords. One is decretal amount, then
If you're
interest and
ready
all this.
short matter, I think whenever it comes, your lordships, I know.
When both of you are ready?
October, in the month of October. my lords.
October.
In month of ending rahele bhalo, because I think initial October, your lordship
October,
itself has placed lot of
And
matters.
after holiday?
Huh, after
after
puja holiday.
Puja holiday?
Puja holiday.
So let it come on 30th.
30th.
Reopening day.
Reopening.
31st.
Okay, 31st.
31st.
Okay,
The
30.
hangover will not be over, so 31st.
Okay, 31st.
My lords, they will deposit, my lords, the awarded amount.
Awarded
No,
amount.
That interest and all these things.
The awarded amount, why? Because because we're saying one
Interest bearing
thing go down.
interest bearing account.
So that will be kept there. So far is that
awarded
awarded
amount.
No, awarded amount, sir. Chinta hai nahi. The minus of director that to keep it in interest bearing account. There is no problem. Minus directed to keep it in interest bearing account. So there is no problem. Only thing is that minus to interest accrued in the bill.
Your interest is secured, don't worry.
The interest is secured. So only interest
No,
accrued upon
if
that
that
decretal
claim
amount.
of mine is, if
Decretal amount.
if that is
Sir, that will be a separate order, don't worry.
Okay.
This,
Okay.
if everything go in your favor, then that will also go. You will take the interest also.
Okay.
Okay, next.
Item number 9.
9.
May I please, Lordship?
Yes.
Lordship, my loan application has been rejected by the opposite bank as because of the poor civil score. As I am the guarantor in certain loans, but Lordship, it is revealed.
Now what do you want from the court?
Lordship, it is revealed from the civil score that has already been closed, Lordship. And Lordship, kindly glance at that, Lordship.
Close means those
That
loans
commercial.
where you have
Yes,
your
yes, yes.
guarantor.
Yes,
Those
Lordship.
loans have been closed.
Yes, Lordship. Despite
Which bank?
That is Lordship Indus&, Lordship, kindly glance at the Lordship's order that is dated, Lordship.
Madam, এটা কোটি কি আপনার ব্রাঞ্চ কোটি?
সেটা হচ্ছে এইটি লর্ডশিপ আপনার লর্ডশিপ 14/3/2023
কলে?
Yes, Lordship.
কোটি?
করেছি স্যার and consolidated plaint also I have filed, Lordship.
File?
Yes, Lordship.
Fine, কোটি?
Correct. Court.
ଅଛି ନାଇଁ ଏଇ କନସଲ୍ଟ ଅଛି
File करने के लिए allow है ये amendment का allow है सर
ହେଇନି amendment application ହେଇଗଲା
Allowed.
ହେଇଛି
Yes,
ଆସିଲା ଆମର ଏଠି ନାହିଁ ତ
Lordship, that is order dated 1 minute.
ଅର୍ଡରଟା ଖାଲି ଅଛି ହେଇନି ଆପଣ ହେଲେ ହେଇନି the consolidated petition is allowed issue notice to the
Opposite party number 4. Lordship, I have already issued notice to the opposite party number 1, 2, 3.
no 4 को କରନ୍ତୁ
Yes, yes.
सी ଆପଣ ଯୋଉ ପାର୍ଟି କରନ୍ତି ଆପଣ ଇଜି ଜିନିଷ କାଇଁ କମ୍ପ୍ଲିକେଟ କରନ୍ତି बैंक ब्रांच तो अच्छी कटक रे की भुवनेश्वर रे ए ताकू ब्रांच मैनेजर को पार्टी बने अपन सीधा कौन करे वाइस प्रेसिडेंट ऑफ एक्सिस बैंक को पार्टी बने
जो
वाइस प्रेसिडेंट विषय जानि भी नथो अपन लोन की नै छी कोन जानि नथिबो से ओवरऑल पॉलिसी मेकिंग इशू डिसाइड करियो ताबू पार्टी बने देबो
My loan application has been
your loan
rejected.
application may have gone anywhere but the loan where you have the bank where you have approached that should be that bank should be the party ଏମିତି କରିକି ଆଗ amendment କରିବେ ଏଟା ସାଧାରଣ common sense use କରିବେ before making party
Lordship, I have already filed the
that is allowed okay notice issued to the registered post to give a copy okay next
item number 10
Lordship, date Lordship
25th 25th नहीं September these things I don't take much time 10
item number 10
from 10 my lord last time we directed to file affidavit enclosing the resolution regarding engagement of junior teacher of 2019 and 2023 we have already filed today we have filed e-filing counter and
but we don't have that copy अब आज ही फाइल करबे आज ही टच काई है
एटा केबे ऑर्डर करथिले सर को तारीख रे देयर इज व्हिच डेट बिकॉज़ अकॉर्डिंग टू माय note there is no such direction উনিশে
So we have not received, sir. Give him a copy. Okay. Copy does he have? I'm fixing it on some other day. Copy has in. This the matter on 22nd as well.
Sir, just a minute. ମୁଁ ଜାଣିଲି ସେ କ'ଣ ଠିକ ଦେଇଛନ୍ତି ଦେଖିଦେବି ନହେଲେ ସେଦିନ ଫେରେ କହିବେ ମୁଁ କହିବି ଦେଇନାହାନ୍ତି ସେଠି ଫେରେ
ଆମ ପାଖକୁ ଆସିନି ଆମ ଫାଇଲରେ ନାହିଁ ଏରେ କ'ଣ ଇସ୍ୟୁ କ'ଣ ଏତେ ଏତେ ଲମ୍ବା କଣ ହେବ
Sir, ଇସ୍ୟୁଟା ଇଜ ଭେରି ସିମ୍ପଲ
ଯା ମୁଁ ଏମିତି ଡିସାଇଡ୍ କରିଦେବି ଆଉ କାଇଁ ଏତେ ଦେଖା ଦେଖି ଯା କହ କ'ଣ ଇସ୍ୟୁଟା କୁହନ୍ତୁ It's a small issue, why should you take on? So, what is the issue?
Post of Shiksha Sir.
That is fine.
Here, block was a unit by that time to apply for the post of Shiksha Sir.
What is?
One block. And what happened, the petitioner has applied for post secretary.
ସେ ରେଡି ନାହାନ୍ତି ସାର୍ ମୁଁ କହିଦେବି କି
Yes, yes.
ଆଜ୍ଞା
Puri block.
ସାର୍
Puri revenue district, sorry.
As per the principle, my lord, the Shiksha Sahayaks are to be selected pursuant to education district basis. Whereas, while the advertisement was floated for education district wise, an amendment was caused by the authorities, putting it block wise. Education district contained number of blocks, my lord. This was challenged before this honorable.
So education district is a DEO. On the DEO.
DEO.
So
But this is under the, it's a special scheme. Sir, what has happened? This incorporation of block wise was challenged before this honorable court.
Okay.
This honorable quashed that. Said the selection is to be made not only block wise, district wise. Accordingly, the advertisement considered, and I was selected pursuant to my merit list. In other words, my lord, all the applicants who are within the education district are to be considered taking into vacancy position in toto and taking into the merit position of the candidates of the education district. I was selected. I was there. However, my lord, what has happened? Suppose the advertisement was for 100 posts and there was a notification that about 150% posts are to be taken into consideration. Excess of the advertisement post, some people were appointed. Accordingly, this honorable court that was challenged, this honorable court decided if anybody is appointed, excess of the advertised post is to be terminated. Very good. But a condition was there. For such next advertisement, such persons are to be given consideration, they can apply. We applied. I applied. In the second process of advertisement, they are to select it in education district wise. But here they did not choose it in education district, they choose it block wise. Your lordship will kindly appreciate. In education district, there are suppose 100 posts of Shiksha Sahayaks. The scheme is 70% to be city candidates and 30% to be the B.Ed candidate. I was the candidate for the B.Ed post. Whereas in the case of a block, the post comes to 7 or 10, the percentage goes. That means if it comes to 10, 7 will be for city, 3 will be for B.Ed. Therefore, they're taking into block into consideration. They found that I am taken against the block, and accordingly they found that I'm not a meritorious candidate. But had it been taken in the district wise, education district wise, I would have been selected because persons those who have secured lesser mark than me have been selected because they are taken block wise consideration of different blocks. That was challenged. Under this process, my lord, what has happened?
So you are challenging the block wise.
Yes,
the recruitment
selection, block wise selection because
so you have what is the prevalent system? Block wise or district wise?
Sir, district wise.
Here, what my lord? He has not challenged the advertisement. He participated in the election process.
It's fine.
Yes, my lord. Let me. Selection process. She didn't qualify. Then she remains silent. One.
But the question is,
Yes.
that part, but this is, I'm asking a very
Broader view.
broader thing. If a person, if there is a district, unit is district, then why block wise unit is, you have?
No. By the 2006, the block was 1 unit.
2006.
Yes. And she had
But he has applied in which year?
2006. Advertisement is she has annexure.
2006.
Yes. Annexure 3.
31st May 2006.
Yes.
So at that
She
time.
did
2006
challenge that advertisement.
At that time, it was blocked.
Yes. That was not challenge. She participated in the process. Once a person participates in a process and on being disqualified or yes,
Law chhod do na. This I'm asking what the problem? Suddenly why did you again switch over to district wise?
no, not switch
You are
over, not
blocked.
switch over.
Later you have again switch over. to
Madam,
district.
one thing. I'm not switch over. We are not switch over. Here what happened? One Chandramani Jana filed a writ petition alleging that in that I belongs to X block, but I have applied for Y block. But they have rejected her candidate on the ground that you can apply for your own block. So that was on the challenge, and the court held this
And this man applied
in
his
her own block.
Own block.
There is no issue to that. Now they are referring to this Chandramani Jana case. That is completely separate. In that case, this honorable court held that no, on the ground of residence certificate, you cannot reject their application. So this case is completely different than Chandramani Jana case. But they are claiming or relying upon that judgment. Now they are claiming this benefit. So here, once you have participated in the process of selection, you didn't qualify. Now you are saying that no, I'm that should be the advertisement is wrong. How it can be?
Okay.
When game over, for the question of changing of rule. ଆଉ ଶିକ୍ଷା ସହ ପାଇ ଗଲାଣି ସେ 2019 ଗଲାଣି 2019
Where the game is, where the game? Game is not there at all.
yeah, well, rule cannot be changed after game is over.
When the rule change? Rule is not changed during the game.
What they are saying now after participation after fill up
That
the
is fine.
post,
That
yes,
is fine. But
and now after 6 years or 3 years they approve this honorable court challenging this all these things.
I think my friend is arithmetically very wrong. I have filed the case within 3 months. What is the 6 years?
But they are not challenging the advertisement.
Why should I not? That goes in my favor. Why should I challenge?
Yes.
advertisement, he
He
is saying that this block wise thing should have been district wise. That is what he is telling.
Yes, but that's they should challenge soon after publication of advertisement. Instead of that, after you fill up the post, they approve this honorable court.
Okay.
Challenging the advertisement.
Okay, you give me your written information.
Yes.
My lord,
I will also simultaneously, I will pray my learned friend kindly go through that advertisement.
my lord,
I have given a copy to him. Yes.
my lord, may I draw your lordship's attention? My lord, there is a matter which is analogously listed in that item number 10.
10.
Yes, well, there are two matters. My lord, my learned friend appearing for the state is purely misconceived
He has not read.
in making out the submission with regard to the advertisement.
Namu
My lord, just with the lordship's permission, I am just clarifying what was the actual fact. No, the court is reserving matter, I think.
Yeah, this is a simple,
No,
this is clear, as clear as water.
It's urgent.
No, I'm not adjourning. I'm reserving it. What is there to?
No.
Again?
Your lordship, my lord, the
Please.
fact, whatever he is
A
placed.
small issue.
No,
Sir,
yes,
sir.
it's a small issue. The fact, whatever my learned friend has placed, that is wrong. My lord, one,
I have not just adopted whatever he says.
my lord, just for your lordship's clarification, I'm just making out a submission. A composite advertisement was issued by the director in
What is
respect
that composite advertisement?
composite advertisement
What do you
covering
mean by that composite?
composite mean one advertisement covering the entire state with a particular clause, that is 4.1, regarding method of selection.
Okay, that's
Which-
later.
No, that was the advertisement. I am talking about one advertisement.
That advertisement.
Yes,
Yes,
your lordship kindly bear. Well, one advertisement containing one particular clause at 4.1, which deals with what should be the method of the selection. There, this method of selection became blockwise, which was challenged before this honorable court, and this honorable court in the division bench judgment,
hold that this restriction or the modality prescribed under clause 4.1 is wrong and it is quashed because it is violative of article 14.
Okay.
So that once that is there,
Order reserve.
ନାଇଁ ସାର୍ ଆଉ ତାର ଫର୍ଦର ଡେଭଲପମେଣ୍ଟ ଅଛି ବୋଲି ମୁଁ କହୁଛି ସାର୍ କଣ ତାପରେ କଣ ହେଲା ସାର୍ ଯେତେବେଳେ after this judgment was delivered by this honorable court thereafter 300 some odd posts which could not be filled up in Puri district. My learned senior also appears for a candidate for Puri. I also appear for a candidate in Puri. In Puri district, which were originally earmarked for ST category, remained unfilled. Government decided to de-reserve it and fill the same up through regular mode. And there, despite there is a judgment of this honorable court quashing that 4.1, they still conducted the selection after the judgment was delivered, but again insisted upon blockwise. Thereby, what they did, even if I have secured 123 marks, I was not given, and a persons who are they themselves have admitted in their counter, the person who has secured 67 and 78 belonging to Konasa block has been given appointment. I have implemented them as parties in my case. So this is the thing which I challenge, that after the law has been laid down by this honorable court relating to the very same selection with regard to the very same advertisement.
What is the law laid down?
Law in place.
What is the law laid down?
Law is that Chandramani Jena's case.
What is the law laid down?
Law is you cannot deny a person right of participation on the basis of place of birth. That they did by putting that blockwise the restriction saying you can make your application only in respect of the block. The honorable court said, if at all you insist this particular clause, that is violative of article 14 and 16 and 15. That is what the law has been laid down.
Give you a short note.
Yes. Sir, one thing with the due prayer, my lord. One affidavit they have filed in the court. We will have to go and see that. What is the affidavit?
Sir, see the affidavit and give a short note. Matter will be over.
Sir, short note, sir, long note.
Long note diyantu.
Mu deichi, sir. That is my lord's brief.
Cover karike diyantu.
I have given. I do not know whether my lord has that is in my lord's record or not, because
that is
sir, got a minute. Prior to that, there was a judicial order on 16th of 2nd of December 2015, order number 10 by my lord Justice Prasad. And last order was
key matter ta 14 varsh lagibo kono hearing pai 14 minute re sari jibo
sir
apne 14 minute hegala
sir mu janichi our intelligence is lesser than your lord's intelligence, but the question is that
always learning from you, sir.
The question is, if they have given a document and they have not relied on the advertisement of 2006, your lordship must have to go through that.
Yes, please, you deal with your note. I'll deal with everything.
My lord, can I?
Don't worry, my final product will.
Yes. My lord, can I draw your lordship's attention to only one page of that affidavit filed by them? Only one page. I have just for your lordship's convenience. I have just.
Sir, not in vice the note they should see it, sir. Not in vice.
My lord, this part.
Note
sir, ठीक है mark पे देखिए.
Tell out of the.
Sir, ठीक है sir. देखो सही page तो देखो last paragraph. This affidavit was filed in compliance of the order passed by the honorable court. They themselves have admitted opposite party number 6 and 7 has secured 70 some on next page. Your lordship kindly turn over to the next page. Next paragraph, your lordship see what is my mark.
You prepare a note. Give me.
So despite that, I have been thrown.
Understood, sir.
Oble. I'll do.
You prepare a note.
Okay.
Sir, more note achhi ki dekh sir.
Achhi. Our note power.
Sir, not in vice.
Achhi. आजा अच्छी सेतिर अच्छी 89 चलो
ताल सर मोटा आउट नोट दे इटा देला पर
आउ दरकार नहीं जदि आपण
एटा जोड़े
चाहिए दे पारे
sir problem setting में he has given a note, given an affidavit that may confuse my lords.
No
sir
they not confuse me
no sir mu te tel umupra koini I'm little backwards over these people.
No I'm not getting confused, don't worry. I'll not be confused. Sir, this is simple thing. Why I should be confused? It's not rocket science that I'll be confused.
Sir, rocket science.
Chandrayaan hai tantala haan dimag chalna tha.
Hame Odisha re kon rocket.
That's all. So that any point you can't say that this point has been left out. So I can also deal with those points. That's what I'm saying. So if you want to give me, I'm just giving you for 5 days time. ଆଉ ଦିନ ଲଗେଇ ଦଉଛି ଆଉ ଦିନ ଖାଲି note ଦେବା ପାଇଁ
Don't sign notable.
note ଦେବା ପାଇଁ ଆଉ ଦିନ ଲଗେଇ ଦଉଛି 27 note ଦେବା ପାଇଁ
Hon'Ble.
for giving note
27
September.
that will come in the list.
ହଁ
Hon'Ble.
note ଦେଲେ ଯେ list ବାହାର
Hon'Ble.
ପଳେଇଗଲେ ରହିଲା ତାପରେ
ନାଇଁ ନାଇଁ ନହେଲେ ରହିଯିବ ସେଇଦିନ ଆସିବ ଆମେ ନୋଟ ଦବୁ ସେଦିନ ଦରକାର ପଡ଼ିଲେ ବୁଝେଇ ଦବୁ
ଓକେ ଠିକ ଅଛି next
Item 12.
12
Item
12.
12.
Well, item 12, I have no up-to-date instruction, but it can be disposed of as no instruction with liberty.
next
Item number 13.
13
13 is the same one,
same
same as 12.
same as 12 14
14 adjourn hearings.
adjourn
Item 15.
15.
Round council of the state to file the contributory, then this time. Fifth. Next,
Item 16.
16. Nine. None appears for the petitioner. On 28/8/2023. Also, there is none to represent the petition. It seems that the petition is not. Hello. Next. Next.
Item 17.
17.
17 I am for the petitioner.
Yes.
In this case, counter and agenda has been filed. Kindly see order dated 12/5/2022, my lord.
12/5/2022.
Paragraph 3.
Come on, pardon.
There is no reference in the counter in dealing with this statement. In fact, pleaded in several paragraphs of the petition. Paragraph 4 of the writ petition has not been dealt with at all. There is no disclosure in support of statement made in paragraph 11 in the counter. There is no dispute, therefore, that petitioner committed default by not paying installment due to April 2020 and thereafter. The bank commenced action on default by the first letter dated 16 September 2021. There is no explanation for the delay. Court will hear the bank on adjourned date on why there should not be presumption of waiver of right to take possession of the vehicle and if the possession taken thereafter being wrongful. The case of the petitioner is that the vehicle was seized and during the COVID-19 period, he could not able to pay the installment in time, for which the notice has been issued and thereafter the vehicle was seized.
Okay.
And thereafter he challenged the same before the Hon'Ble court. And he has given the offer for settlement of the loan account, which has not been done.
So today, what do you say?
Today, petitioner is ready and willing to.
Ready and willing. କେତେ ଟଙ୍କା ଅଛି?
କେତେ ସିଏ ତ ତାଙ୍କ କାଉଣ୍ଟରରେ କିଛି ଡିସକ୍ଲୋଜ କରୁନାହାନ୍ତି।
madam?
What counter according to their own writ petition, my lord, it is the admitted fact he has taken loan for
No, no.
purchase of
ଆପଣଙ୍କ outstanding କେତେ ଅଛି?
outstanding, my lord, till 20th September 2021, it is 27,49,733.
27 lakh. So you want to pay? You're saying ready and willing, na?
Yes, yes.
So by what time will pay?
Your lordship may keep it Monday. I will take instruction from the client because
Okay, Monday.
because
Let him take instruction, madam. If it is, if they can pay, things will be closed.
Yes, madam.
But actually, my lord, after sale notice, my lord, it was sale notice of 10th January, and he has filed the writ petition on 14th March, my
Selling
lord.
ହେଇଗଲାଣି? ହେଇସାରିଲାଣି?
Huh. And he was also given offer, but he could not participate.
अबे कौन टा होगा?
ସେଲ୍ ହେଇଛି କି ନାହିଁ ସେମାନେ କାଉଣ୍ଟର କୋଉଠି ଡିସକ୍ଲୋଜ କରୁନାହାନ୍ତି ଆଜ୍ଞା, ସେଇଥିପାଇଁ କୋର୍ଟ
14.3, my lord, he has.
आपण
filed the
सेल करके
repetition.
कितना पाइले सितरू
Repetition, my lord, 14.3. After 3 months, he has filed the repetition and he has received the notice prior to the sale
आपण केते
also.
टका पाइले से सेल रू
My lord,
केते टका पाइले सेल रू how much amount you derive from the sale
ସେଇଥି ପାଇଁ ଏ ଅର୍ଡର ଟା କରିଥିଲେ ସେତେବେଳେ ସେ କିଛି
That is
ସେଠି
not
କିଛି ଲେଖି ନାହାନ୍ତି ସେଲ୍ କରିଦେ ବେଲା
I'm
କଣ
asking what is the amount you have
let it come on Monday, my lord.
okay
I will-
Monday Tuesday as a Tuesday then comes to the state to sorry the bank to obtain as to whether this the vehicle in question has been sold or not, number one. If sold, what is the amount received from the sale proceeds?
My lord, bank has also filed OA in debt recovery tribunal also, my lord. That is also.
that is separate thing man
That is
OA
separate
OA
thing.
is not the related to
देखो,
sale
आपण
Recovery of the loan amount we have.
and
filed
entry
in
model may
tribunal.
continue there is just order of
what is the interim?
Stay କଣ?
ଆଜ୍ଞା ସେମାନେ କହୁଛନ୍ତି ମୋରେ କିନ୍ତୁ ସେଟା କାଉଣ୍ଟର ରେ ଲେଖି ନାହାନ୍ତି ବୋଲି ସେ
interim order to continue.
Sale
entry order to continue man
ଆଉ ହେଲା ସେଲ୍ ଆପଣ ନ ହେଇଥିବ ଯଦି ବହୁତ ସମୟରେ ବ୍ୟାଙ୍କ ସେଲ୍ କରି କେହି
ହଁ।
କିଣନ୍ତିନି ସେ ବି ହେଇଥିପାରେ ଘର ଯେମିତି ଅକ୍ସନ
restraint from issuing public notice for sale of
Baharat.
vehicle till next date man that is the entry model
That's it.
entry model may be
That is coming on Monday na?
Monday Tuesday
Monday na Tuesday. Tuesday ତ ପୁଣି ଛୁଟି ଅଛି 21st ଅଛି
21st entry model may be continue
next
Item 18.
ନା ନାହିଁ ପରା ଛୁଟି ଅଛି ନା 19 20 ଛୁଟି ଅଛି
ସୁବିଧା ତ ଅଛି ଆଜି।
21st
25
class
As per your lordship's direction, I am filing
19
counter today.
19
18.
I am
Yeah.
filing counter, my lord, opposite party number 3 to 6, serving copy.
what is the issue what is the issue sir
Because the bank has withdrawn the money without the signature of the petitioner.
bank has
Yes, Lord.
bank has done how bank is
Petitioner has not signed any document
Hmm.
and without the 20 lakhs.
without sign
Yes, Lord. Fraud has been done and now they are going to.
they admit that fraud
Yes, Lord.
they admit
No.
କେମିତି ତାଙ୍କ ପଇସା ଅଲଗା ଅଲଗା ନେଇକି ପଳେଇବ ସାର୍
You should kindly see.
This
Annex
was
check.
taken over, one
Annex
loan was
check.
taken over because one person was property owner, mortgaged the property and he was housing loan. And that was taken over by the present petitioner, number 1. And that he has taken the land money and construction money. Though that has been transacted.
where are you here where are you here
Yes, Lord.
why are you here today
Because they are now going to auction the in his land and the proper building.
Already property
Both.
sold.
And now vigilance case is
let him
pending
find
on-
out what is the status the petitioner is directed to find the status of the property
Well, now
property
there is-
status ବିକ୍ରି ହେଇଛି ନ ହେଇଛି ସବୁ ପତା
Three ଆଉ ଜଣେ କିଣି ସାରିଲାଣି, that is admitted.
ଆପଣ ଆଣନ୍ତୁ ନା
The
ଗୋଟେ
earlier writ application was filed. On the basis of this, writ application was disposed.
Vigilance case is pending on auction. Held up. Vigilance case is pending.
The internal vigilance case.
ଠିକ ଅଛି you just find out what is the status of it
My lordship, on behalf of Sri Tuna Sahu, through the VC, my lordship.
this is the matter on 27 yes next
Item 19.
May I please, your lordship? May I please, your lordship? Kindly see the last order, my lord.
yeah
Order dated 5th May. Once issued notice specifically directing opinion 3 to so cause to why the payment has not made. In spite of the claim referred to him under Annex 4, page 19, kindly see me, Lord. My claim has been referred by the District Cooperative Bank to the opinion 3 for a settlement of the insurance claim.
why have you come here
Sir, Monday. छोटिया
why
मैटर
are you here
सर छोटिया मैटर
ଆପଣ କଣ ପାଇଁ ଆସିଛନ୍ତି
इंश्योरेंस टंकाटा दउनांती इन स्पाइट ऑफ द
किसान क्रेडिट कार्ड
इंश्योरेंस
किसान क्रेडिट कार्ड
यस मिरो
ଦଉନାହାନ୍ତି
नो Page 19 ना वाले खाली 1 second. Page 19 annexure 4.
अरे सर annexure पछे छाड़ दो ना आपन को दो ना दिगी
No, everything has been referred to the insurance company. Open the matter.
consumer district consumer protection officer को कम में पार्टी करछन
ताको सर गोटे दरखास्त देइथिलु बोली पार्टी करथली. In fact, my lordship has taken the cognizance of the matter. My lordship so that my lordship issued notice of number 3. Considering the gravity of the case.
ग्रेविटी क्या क्या बोलते हो यहाँ पे आ जाओ
Yes, sir.
यहाँ आ जाओ
जी सर.
Nayagarh is not the right place for you.
Yes, madam.
Huh? You come here. We'll see.
Yes, yes.
Yes. Listen, madam. इची कम पूछी पर नहीं था कथा.
Monday, Tuesday.
हाँ Tuesday तो छुट्टी है. अच्छा ये Tuesday 12 रे आसो हाँ 12 ठीक है 12.
Public.
Okay, your voice, you are missing your voice, sir. Come here. Counter. SB.
No, I am for the employee.
EPF.
I have filed my count.
You have filed the EPF. You want to file. Okay, let us consider the EPF, Mr. Mohanty. 6 1 week time to file the counter. 2 weeks time to file the counter. This is the matter. 12 October. 12 October. Next.
Item 21.
खाली काउंटर रीजन में टाइम नहीं होता केस
My
में
lord.
सुनी लेसन आप वो
Little early, my lord. 12
Society Registration Act.
अच्छी
Suit is maintainable.
शूट इज मैंने
My lord, again, any
हाँ आगे कैसे शूट तो फाइल लेते हैं चलो
এটা amendment কি insert ହେଇଛି ଆଗରୁ ନଥିଲା
କେତେ କେତେ
11A
Section 11A.
ଆଉ ଏଇଟା ଏରେ ପୁଟ୍ କର Learned concept of the petitioner submits that is the state submits that since the issue under adjudication is an appellable one, the petitioner appeal na it is
Suit file.
sorry, not appellable. It is the subject matter of a suit, and the petitioner should have approached the civil court for adjudication of the disputes. According, he further submit that as per section 11A, the petitioner should have, the petitioner is required to go to the civil court.
I have filed a representation before the collector.
Representation is a suit. Reputation.
Urgent copy.
Dispose of.
Urgent copy.
You have filed the suit. Suit माने भी आज जल्दी हो जी सर सब suit late होनी को कोड़ा late हो जी सब suit late होले मैं मानने आपण गोटे notion हला जे suit माने late हो
ରାଜଧାନୀ ବସ୍ ଅନୁଶାସନ ତାଙ୍କର ସରିଗଲା ଆପଣ
सब
ଟାର୍ଗେଟ କରିଥିଲେ କି ମାସରେ ସାରିବା ପାଇଁ
suit माने our young officers are very smart. They're doing it faster.
Time limit भी
ନାଇଁ time limit
time limit ମୁଁ କେମିତି
ଏଟା
कारण ମୁଁ ତାର board
fail
ଜାଣି
କରିବେ ତାପରେ ପୁଣି
ଆପଣ
publish ଅଛି time
ଜାଣି ମୁଁ କେମିତି time limit ମୁଁ fix
since last 20 years no election is
sir 20 years election ହେଇନି हां कौन करथले ताले 20 years तक आपण आपण आगु in case a suit is filed the learned civil judge shall take steps to expedite the proceedings and pass the proceedings and decide the suit at the earliest possible. Next.
23.
23 I have to file a rejoinder, my lord.
Learn concept for the should be.
Well, I'm for opposite footnote 2 and 3.
Yeah, for should be.
No.
Your lordship may call it on.
Oh, अच्छा से जो
Again. Again.
Yes. 26.
India asset recovery.
I'll file a rejoinder. They file a counter.
Okay.
We have only filed.
You file or you have to file?
I will file.
You okay. Learn concept for the petitioners to file a rejoinder. Please 2 weeks time.
26 your lordship may call it.
26. हाँ ठीक है 26. Next.
Item 25.
25. 25.
On 25 there is a noting that
instead of the last order of your lordship, still requisites have not been filed to for the private opposite party number 4.
Requisites, land conference petition to file the requisites at the earliest possible, preferably within a period of 1 week from today, failing which the writ petition shall be dismissed without reference to this court since the matter pertaining to year 2010. Defects. Next.
Item 26.
26.
26, my lord, I need 2 weeks time to file the counter.
State to again 2014 matter na
It has already made ready, my lord. I can show you. It is there, your lordship. I'll just you will come and file the affidavit.
Okay. On the request of Lord of the State, list the matter on 29th. Also. Next.
Item 27.
27.
My lord, due to my illness, my lord, I could not able to show my face, my lord. I had to come to medical for blood test, my lord. Dilip Rai, I am saying.
कौन है सर? कौन है? आपको देख नहीं पा रहा मैं.
Dilip Rai, my lord, I am not in properly dressed, my lord, for which I could not able to.
Then there will be cost for you. October.
Oblige.
End October.
Hi, oblige.
ना और कुछ बात.
Click हो.
हमने बोला ये थे तो. By the time.
15 अक्टूबर 15 हो चली.
अच्छा अक्टूबर 15 तो छुट्टी 16 कर दिया.
Oblige.
Okay, next.
Oblige.
28.
In this case, the government has filed counter, and last time I also take time to file register, but I sought for certain instruction from the RTI. For that reason, I prayed for some time and
कौन RTI मांगू चना क्या?
the certificate which has been annexed by the government under
Who certificate?
annexer DY.
Who certificate?
Certificate of this.
अच्छा मते RTI information मांगू चंदी तो गोटे कथा मते कहबे.
Sir.
Whether RTI information is admissible in law or what is the admissibility of evidence produced which is obtained under RTI?
File the region.
ना सेमती हेबनी. आपण सेटा मते देखबे law देखबे तापर. Admissibility of information sought under RTI. देखबे. ता सारे तार मते हेडर देखबी तापर डिसाइड करबी. हला नेक्स्ट. This is matter on 10th October. Next.
29.
Certified copy नहले evidence रे निया हबो नाही. Certified copy हेले हबो. RTI रे certificate तो दो ना दी. Most of the time they दे दो copy.
My lord, government has given counter that this petitioner is residing in the Amrapalli number 2. This is the counter given.
Amrapalli, Kodi. Delhi.
Sonpur district.
Residential certificate and the certificate issued by the
RTI रे मागिबे residential certificate RTI रे मागिबाटा भाई difficult कथा.
My lord, may I prefer see the counter of government page 5.
এটা কেবে কার কেস আগে এটা?
2022.
2022 আচ্ছা.
My lord,
ঠিক আছে, let him take time. Okay.
Short date.
9th October আছে.
Interim order continue.
Interim order আছে interim order কম short দেব. 21 দে দে 21. Interim order वाला को বেশি সময় কেন দিবি?
ঠিক.
Next.
29.
29. 29. Okay ना दे. 23 तक कम Okay, non appears.
Last time also nobody appeared, my lord. On
Non appears.
28 July.
बढ़िया काट दो.
On 28 July.
Okay, non appears today. On last date of listing on that is on 28/7/2023 was also non found to be in the case. It seems that the petitioner is not interested to pursue the matter. It can be dismissed for non-prosecution. However, if there is any cause of action, if any cause of action arises, the petitioner is granted liberty to approach this court within 1 month from today. Hello?
Item 30.
30, on behalf of Mr. Senior Counsel is Santanu Sodang Mailer. Some time may be
ଏବେ ତ
allowed.
ଥିଲେ ପରା?
He is in lex in the other matter. Some time to allow to counter affidavit. 3 and 4.
जल्दी जल्दी काउंटर क्यों नहीं फाइल एक भी केस खाली मैं एडजन कर बसছি मैं काम
पड़े-
करा
ପୋଡି ହେଇକି ମୋ ସ୍ତ୍ରୀ ମରିଯାଇଛି ପ୍ଲସ୍ ପୁଅଟା ଇଞ୍ଜୁର ହେଇଯାଇଛି।
ଆପଣ ଭାରତ ପେଟ୍ରୋଲିୟମ ପାଇଁ
नहीं भारत का नारायण पर इंश्योरेंस को 3 and 4 ICC लो।
ठीक है लगा दो 30 seconds
Obliged.
Item 31.
31
Sir, 22
The
22nd.
the petitioner, the wife of the deceased mother, who died
petitioner is the wife of the deceased
mother,
कौन हला
claimed for express compensation due to snake bite. Her husband was expired
snake bite कला
घरे while he was sleeping in the house.
snake bite तो आसुची आपण देना दी
And your lordship may go on the
notice
last-
notice नहीं चलती ना
नहीं चलती।
I have already filed my counter, my lord.
what is
And in the counter itself, the medical report given by the medical officer, there is some ambiguity.
what
He has written that the cause of the death is due to snake bite. However, viscera are preserved for chemical analysis and further reference.
clear है नहीं
परंतु है नहीं. And we have also requested the authority to
please
supply
please
the
get the land council of the state submit that since the chemical analysis of the what is it of the
viscera report.
viscera.
since the viscera report is awaited from the forensic lab the matter I mean is the matter on 12 नहीं 18th October 18th
मतलब case of 2020 my lord.
हाँ
2020
ओ ହେଲା ଆଜ୍ଞା ଏତେ ଦିନ ୱେଟ୍ କଲେ ଆଉ 10 ଦିନରେ କଣଟା
ଖାଲି report ଟା ଆସିଲେ
ରିପୋର୍ଟ ହେଲେ ତ ଆପଣ ଜଣା ହେଇଯିବ ଆଉ କଣ
counter has not been served upon us.
କାଉଣ୍ଟର ଦିଅନ୍ତୁ କପି ଖାଲି
ମତେ ଗୋଟେ ନମ୍ବରଟା ଦେଇ
give a copy
986.
Pardon that.
yes
Item 25.
item
25.